Good morning, everybody. Happy Super Friday, the 1st of May today. I can't believe it's May already. Welcome to TCF Live. My name is Dan Soul. I am armed with a plate of bacon, a V8 energy drink, and a dream of a good morning with all of you. So let's make it happen. We'll start off with Judge Middleton.
Mr. Bush, Vivian is checking in right now. Do you need her services? Is Jose Sanchez Lopez here? If you could go on out, we'll set you up in one of the conference rooms. Good morning, Vivian.
Good morning.
Mr. Bush is here in a timely manner. His client is here in a timely manner, and we're gonna set up a conference room. And our conference rooms are not ideal. They're very small and dark, and the walls are paper thin. But let's get a minute to get them set up. In the meantime, let's talk to Rachel Jeske. Good morning, Mr. Jeske.
Good morning.
You're here with your lawyer, Jordan Harden. There we go. This is a Three Rivers City ordinance case. If I can find it. Also have a busy landlord-tenant docket.
Barbara, thank you for the $10. On camera right now, my plate of bacon. So, thank you very much.
Here we go. All right, the file number here is 26428OT, People versus Rachel Jeske. That's you, sir?
Yes, sir.
You got a ticket for driving with a suspended license on Main Street and Michigan Avenue. This time you weren't on a moped or a e-bike, you were on a Dodge truck, I think. Anyway, driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and fine of up to $500. The prosecutor has agreed to reduce that charge to a charge called allowing another to violate the motor vehicle code. That one carries no points, doesn't get abstracted to your driver's license, won't affect your ability to keep or maintain your license. You understand?
Yes.
Jordan, you did do an advice of rights with the defendant. Mr. Jeske, you understand you'll be giving up those rights by having
Yes.
this plea. I'm still finding my way in here myself. All right. Other than this plea agreement, did anyone promise you anything to get you to plead to this?
No.
Threaten you?
No.
Now, you know better than this, but where were you going on March 11th?
I was dropping off help for doing the cleanup during the tornado. And yes, it was about 3 o'clock, but we were going from the hotel to my house and then back, dropping them off up down by the Shell.
Well, it was 2:26 a.m. The
Yeah.
tornado hit on March 6th.
I was doing major cleanup for 3 hotels for almost a week straight.
All right. And whose car were you driving?
My neighbors, he'd allowed me to borrow it so that I could try and get some of the cleanup done, just for the purpose of what had happened.
Were you volunteering or were you getting paid for some of this stuff?
Half of it was volunteer, but most of it was pay.
Well, good. I know you need work because you're gonna have to pay me some money. All right, and your license was suspended at that time?
Yes, sir.
Fine is $100. There's a $75 crime victims' rights fee, $50 state minimum fee, and $150 attorney fee. That's a lot. That's $350. Plus you have an unpaid fine. Well, I'm not sure frankly what the status of that is. It's
Your Honor, part of the reason that he was made the offer that he was because he was able to pay off his fines and get his license reinstated.
all right, very good.
So it's very possible he's totally all paid up with our county.
Good. He's got some sort of zoning thing with the city, but I'm not sure what the status of that is. So today's 5/1. Can you pay that today or do you need time?
I can pay it in full on the 7th.
I'll give you till the end of the month, May 30. The fine's only $100. Actually, I'm gonna make it $75. That comes out to $350. But that's a lot. State cost, the attorney fee, but we did get this negotiated as to one of these charges. Oops, May 30th. All right, if you'd give that to him.
Yeah. And
All right, Mr. Jeske, you've probably got plenty other cleanup to do. Hopefully you can get enough money to pay these fines and you're good to go. Do you know if someone's helping Mr. Bush get set up in there? Vivian, as long as you're waiting, let's go ahead and swear you in. You swear or affirm any testimony, or excuse me, to the best of your ability, you'll interpret these matters from Spanish into English and English into Spanish.
I do.
Thank you. Have you done anything from one of these new conference rooms yet?
Yes, I have. Yes, I have.
As you know, they're not ideal, but we're just doing the best we can. Apparently, they haven't got that room set up yet. Mr. Lambert, would you come up and have a seat? Luke, how much have you got?
Mr. Swick and Mr. Price.
All right, we'll take care of Mr. Swick in a minute. How are we doing? All right.
Fancy.
So good morning once again, everybody. It is TCF Live on a Super Friday. As is the usual case on a Friday, things are off to a little bit of a slow meandering start. That is kind of just the way that it flows. But we'll continue to ride with Judge Middleton for a little bit.
Intoxicated. Unfortunately, we get lots of those. Let's take a look at your ticket. Jordan's of the theory that if you get in early, you get out early. So she always tries to be first in line. And there's something to be said for that. Mr. Lambert, you got a ticket on South Main and M86, and you're where the tank is parked. at the American Legion at 8:38 in the morning on March 9th. March 9th was a Monday morning.
I don't believe it was 8:30 in the morning, Your Honor.
It says 8:30 a.m.
Yes,
Maybe
10
it's not
o'clock,
correct.
like 10 or 11 at night, Sunday night.
At any rate, they pulled you over and ended up arresting you for operating while intoxicated. We get lots of those, probably 200 a year. Times 47 years. I'm not sure how many that is, but it's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driver's license and requires that your license be suspended. The prosecutors agreed to dismiss that for a plea to a lesser charge of operating while impaired. Impaired driving is better for a couple reasons. Carries 4 points rather than 6. It has a $300 maximum fine rather than $500. Most importantly, it will allow you to keep a restricted driver's license so you can drive back and forth to work, course of employment, treatment, school, other limited purposes. But it'll let you get back and forth to work. You understand? And
Yes,
Ms. Harden, you confirm that's the plea offer, impaired driving?
It is, Your Honor.
And Mr. Lambert, are you going to plead to that?
yes,
Did anybody threaten you to get you to plead to that charge
no,
or promise you anything?
no.
Where were you going at 8:30 on a Monday morning?
Your Honor, the report indicates the stop was on March 9th at 0:21, so about midnight.
All right, midnight. That makes more sense.
Yes.
Who's out driving drunk at 8:30? Well, many people are, but, all right, where were you going at midnight?
I was headed home. I was leaving my daughters from Three Rivers there. I live in White Pigeon.
Yes. Where had you been drinking? At your daughter's?
I was at my daughter's, yes.
What were you drinking?
I drank a beer and a shot of 99 bananas. It was pretty potent. I didn't realize it at the time. I was originally planning to stay at my daughter's house and things just didn't work out. Grandkids were kind of riled up and just,
That often is the situation, that people plan to stay where they are. And they get hungry and they want to go to McDonald's or they want to sleep in their own bed or whatever. Or the guy that was gonna drive them home leaves with somebody else. The problem is when you've been drinking, you lose your judgment and your discretion. And you think, well, I can drive. Your blood alcohol was 0.146. That's more than one beer and 199 bananas. It's almost 2 times the legal limit, but will you acknowledge that your blood alcohol was at least 146?
yeah,
All right.
I can't remember for sure.
He did cooperate, and that's what the PPT indicates. as a
Yes.
stop.
I tell everybody, take the test. If you don't take the test, they suspend your license for not taking the test. And if they reduce it to impaired, you can't get a restricted license. Or if it's even dismissed, you still lose your license because you refused the test. So, all right, let's set this for sentence at a date that works for your lawyer. Jordan, I don't think I've got you set for anything.
I have a couple things. I believe I have something on the 18th, but that's probably not enough time to.
The 18th, that might be. You do have something on the 18th? That's all, it shows all Luke for me.
I have a 10:30, Mr.
Oh,
Torres. He's a
two of
co-def-
those are interpreter cases.
Mine is not,
Oh,
but I think he's a co-defendant with one of Luke's clients, so that might be why. I can, as long as I have enough notice, I can usually make myself available.
how are you for Wednesday? Well, that's too soon. How about Monday, June 1st,
I can make that work. What time, Your Honor?
11? All right, I want you to take this form out to the counter, and they'll get you set up with the probation department to come in for screening and sentencing. Joe, let me ask you to take the whole file out there, but he gets that.
I'm happy to do that, Your Honor.
What?
I'm happy to take Mr. Lambert to the counter for me.
Thank you. Let's see if Mr. Bush is set up yet.
So, Dylan, hey, Dan, and everybody, happy Friday. Great to be here today on my birthday. Dylan, happy birthday. Thanks for taking time on your day to join us. We appreciate that. I'm going to take us over to Judge Anzalone in a moment. But before I do, a little public service announcement, if I may, not only for this channel, but for all channels on YouTube. You've probably heard other creators mention this, but there is not a creator on YouTube, from the smallest all the way up to Mr. Beast, that isn't under attack right now. Demonetization's going on like crazy. It's getting harder and harder for any of us to be discovered. Views are down. And I know why this is happening. It's happening because the algorithm has been changed in such a way that it is now favoring what YouTube refers to as viewer satisfaction. So how they're calculating that is how you interact with a creator. So things like hitting the like button, things like being active in the chat, things like leaving comments after you watch a regular video or a short and hitting the like button there. And also, quite honestly, when you're done watching a video with us, watching another one. All of those things signal to the algorithm that this is a creator that you have satisfaction with, and then they start feeding out more and more stuff for that creator. So I ask you on behalf of this channel and also any other creators that you like to take that advice and please help us out. If you are watching a video and you enjoyed it, even just leaving a comment that says thank you counts. Hitting the like button definitely counts. Watching another video from that creator or us if you're on our channel definitely helps. We all need that right now. So if you can do that, very much appreciated, because we're all fighting a war for our survival. And if you want to keep having channels like this and other different genres and channels that you enjoy, that's what we got to do right now. So thank you in advance for your assistance. And on behalf of other creators, thank you as well. Okie dokie, Judge Anzalone doing sentences this morning.
5-22461FH, in the matter of the people of the state of Michigan versus Kybren Street. And we are here today for sentencing. And you are Kybren Street?
Yes, ma'am.
Did I pronounce your first name right?
Yes, ma'am.
Okay, good. Have you had an opportunity to read and review the pre-sentence report?
Yeah.
Have you had an opportunity to discuss it with your attorney, Ms. Underwood?
Yes, ma'am.
Can you speak up a little bit for me?
Yes, ma'am.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
The probation department has computed the minimum sentencing guidelines to be 0 to 17 months. Do you agree with that calculation of guidelines?
We would agree with that
All right,
calculation.
and I do understand there was the COBS agreement to the low end of the guidelines. So is there anything you'd like to say on behalf of Mr. Street?
First of all, Your Honor, Mr. Street is sincerely sorry for the events that brought us here today. Mr. Street is aware that he should not have a weapon in prison, Your Honor. But I think it's significant to know that this weapon was not used. It was not brandished. It was Mr. Street simply had it. And I think he gave an explanation that I think is probably pretty accurate when he said he felt he needed it. Where he was. Mr. Street understands that there needs to be sanction for this matter, Your Honor. We understand that the guidelines came out to 0 to 17. So the low end would be 0. But we further understand that if the court feels uncomfortable with that, not giving any sanction, perhaps maybe 4 or 5 months would be appropriate, Your Honor, in this matter.
So, Mr. Street, is there anything you want to say on your own behalf?
Just what my attorney said, you know, like she said, I never used a weapon on anybody. I never have since I've been in prison. It was just a lot of things going on at the time. I'm not involved in like any gangs or like religious sects or anything like that. So like when the things that were going on, someone gave it to me and just told me like, hey, if you need this, wherever. So I just had it and was in the wrong place at the wrong time, got caught, you know, maybe it was for the best that way. Something didn't happen down the line, but you know, I regret it. I learned from it and hope I can move forward.
Okay. Thank you. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. So where are you currently?
St. Louis.
St. Louis, okay. So it's a sentence of the court, sorry about that, you will serve 4 months to 2.5 years with the Michigan Department of Corrections. You don't get any credit. We talked about that before because you were incarcerated at the time the offense occurred. There's a crime victim assessment fee in the amount of $130 and $68 in state costs, okay? Understand, I see people come in that should have been released 10 years ago, but they're just serving time on offenses like this, assaulting a guard or whatever.
Right.
So keep that in mind. It adds up.
Yeah.
So right now, my bailiff's gonna hand down to you your notice of right to appellate review. You're gonna initial and date 1 copy. They'll explain where to do that, to acknowledge you received the paperwork.
Did we address consecutive sentencing, Your Honor?
My attorney did, so that's what she.
Yeah, I just said he doesn't get any credit and it's stacked. So yeah, it is
Okay,
consecutive to his
I didn't
current
hear that.
sentence.
Thank you.
I'm sorry. It's okay. So the other copies are for you, Mr. Street. And if you wish to appeal your sentence, you would fill out the information on the form and mail them to the address listed on the form within 42 days.
Okay.
Thanks, Mr. Moore. I just didn't say consecutive. All right. So I've received back a signed copy of the notice of right to appellate review. So Mr. Street, I wish you the best of luck. Thank you.
Have a good day.
You too. So I guess we'll take the other one. Then. Okay, thank you. All right, I got a bunch of jail rooms. Let's see if I have. Ryan, did you have something else? Oh, we have him right. Okay. All right. Let's see what I got. All right, so I have a gentleman in jail Zoom 5. It has a 5 on the wall behind you. What is your name?
Jaheem, right?
Okay. All right, so Mr. Fry. That's file. Okay, so this.
Oh, all right. She probably hit a button. All right. I'll come back to her because she will probably relaunch. But in the meantime, let's go back to Judge Middleton.
Everybody's back here.
Thank you.
I had the door closed because it's so noisy, but this is our new setup. It's not ideal, but we're making it work. Luke, let's talk to your client while we wait for.
Mr. Swick, Judge.
This is file number 26350. Are you Joshua Swick?
Yes, Your Honor.
You got charged with operating while intoxicated with a high blood alcohol level. The file number is 26350SD. At this point, your lawyer is going to ask me to set this for a last pretrial. You've requested discovery from the prosecutor. We'll set a final pretrial on a Thursday afternoon. I don't yet know what date it is. It does show that you owe some money on an improper plate, but I think it's connected to this case. I think it's the same situation. So it doesn't appear there's really any significant unpaid fine. Are you still at Covey Road?
That's just my mailing address. I actually stay over in Allen, Michigan, with my sister.
All right, but any correspondence with the court will reach you at
Yes,
that
sir.
address?
Yes, sir.
All right, couple pieces of advice. We'll find out about that license plate ticket. Don't get in any more trouble. Stay in contact with your lawyer, and I will see you on a Thursday at 2 o'clock on a date we'll work out with your lawyer.
And Judge, it may be of the court's interest, so we're going to make a referral for sobriety court.
Very good. Okay.
Thank you, Judge. Thank you, Your Honor.
All right, I'll be all in your business if we're doing sobriety court, but Luke is very good at it. He's our sobriety court lawyer, and it could make some fun.
Okay, as I suspected, Judge Anzalone just hit a button and she's back. So let's go back there.
Mr. Ani, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
No, Your Honor.
Okay, thank you. Ms. Underwood?
We do not, Your Honor. Some things are open to interpretation, and Mr. Robinson had a different interpretation, but we really don't wish to challenge them, Your Honor.
All right. Mr. Ani, is there anything you'd like to say on behalf of the AG's office before the court passes sentence?
Mr. Robinson.
No, Mr. Ianni.
Oh,
Okay.
We're asking that the court follow the recommendation, Your Honor, with the addition of additional probation. He was paying for a period of time from about May of 24 to February of 25. So he does have some ability to work here. I don't know what happened and why he stopped. Unfortunately, the arrearage that he's accumulated is in excess of $47,000. Which is well above what it was when he was sentenced originally. So we're asking the jail for a jail sentence along with additional probation.
Okay, Ms. Underwood?
Your Honor, I've spoke with Mr. Robinson. He does want to pay this off, Your Honor. He would welcome probation to do that. However, if the court, I mean, his circumstances are obviously very bad, Your Honor. He's living in a burned out building, or, you know. So it's obviously not an ideal situation for Mr. Robinson. And if the court is going to assess a long jail term in this matter, Your Honor, we obviously would ask the court to terminate probation and allow the matter to proceed civilly. That's where we are, Your Honor.
Okay. Mr. Robinson, is there anything you'd like to say on your own behalf?
No, ma'am. I'm going to take full accountability for my actions, and I'll keep trying to get this taken care of.
Okay. So, Mr. Moore, if I could, we sentenced him, let's see, we sentenced him back, well, his articles of probation were February 2nd of 24, and he absconded for a year. So I think I can give him up to 2 more years of probation. Is that correct?
Yeah, you can give him up to 5 years probation, Your Honor.
And, okay, but he's already completed 1?
He completed 24, 25, and so he completed 1, and then he absconded. Was it October? So 1.5 years, something like that.
Okay.
It was around
Thank
the
you.
time my house caught on fire. Yes.
All right, well, thank you. So, anything else, Mr. Robinson?
No, ma'am.
All right, well, it is sentence of the court that your probation will be continued and expanded to 5 years, although I realize you've already completed like 1 of those years because of the $47,498 of arrearage of your child support in this case. I don't know if this case is still charging or not. All your other probation terms will continue, and what is his jail credit at this point? 13?
Correct.
Right. So I'm going to give you 4 months in Lenawee County Jail. I'm going to give you credit for 13 days already. 13 days already served. When you get released from the jail, you're going to need to report to Mr. Moore or whatever. Mr. Moore, what would be your direction?
Yes, he report to me upon his release. If you're released on a Saturday or Sunday, that you come see me. But just plan on it first thing on a Tuesday morning. Okay.
Yes, sir.
But if you get released on a Tuesday, see me on Wednesday.
Okay. Thank you.
Understand?
Now,
Yes, sir.
you also need to understand that the Attorney General's office can charge you again if you're not paying child support if it's active. Do you understand that?
Yes, I do.
Okay. All right. Now they're going to bring to you at the jail or have you sign. They'll give you 3 copies of your notice of right to appellate review. You're going to initial and date 1 copy for our records just to acknowledge you received the paperwork, and the other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right.
Okay.
Okay. Very good. Thank you.
All right. You have a great day.
You too. Ms. Underwood, thank you, Ms. Underwood.
Thank you,
Don't
Judge.
forget it's law day today, Ms. Underwood.
Thank you.
I'm sorry.
It's law day today at 11 in here. Constitutional Law Day, May the 1st.
I'm sorry, Your Honor.
It's law day today, so make sure you come back at 11.
Thank you, Your Honor.
All right. Okay, so Mr. Murphy, who looks totally annoyed with me today, this is in the matter of file number 2025-22427FH, 2025-22428FH, 2025-22428FH. in the matter of the people of the state of Michigan versus James Albert Hall Jr. Miss Iddings, I believe Miss Demont is in back. If you'd like to go talk to her.
Yes, I would like to.
Can you let her back there, please? However she is back there. I don't know where she went. All right, I have Matt Murphy appearing on behalf of Mr. Hall. This is the date time set for sentencing. You are James Albert Hall Jr. Speak up, please.
Yes.
Okay. Come on, you can approach and he'll let you in back. All right, so Mr. Hall, have you had an opportunity to read and review the pre-sentence report?
I have.
Have you had an opportunity to discuss that report with your attorney?
Yes, briefly.
Do you need more time to discuss that with your attorney?
I do not.
So you feel like you've had ample time to discuss any of your concerns with Mr. Murphy?
I have.
All right, are you satisfied with Mr. Murphy and the advice that he has given you?
Yes.
All right, Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Yes, we do, Your Honor, because when this was prepared, obviously, Mr. Hall was at the Haven. There was the incident that caused him to be arrested and the new charges to come. He was removed from the Haven. There was an issue there, wasn't there, correct? And then you came to Adrian, you was driven to Adrian.
I was asked to leave, Your Honor.
So obviously there's that, that issue I guess we had to correct, because it does say, I think it said he's currently in it. I also had that issue in regards to moving forward with an actual sentence. But again, I think that should just be corrected. Also, I think his SSI is 1,042, not 48, I think it said. But other than that, I guess there's no other issues.
All right, and Mr. Stevenson, can we make those changes?
Yeah, like he said, when the report was written, he was in that program.
Yeah, so I think that's fine. He's not in it now. All right, anything else?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
And in this case, the probation department, obviously on file number 25-22427FH, he pled to an operating while impaired second offense, which is a 1-year misdemeanor. And file number 25-22428FH, he pled to a high court misdemeanor police officer assaulting, resisting, and obstructing. And we don't do guidelines for those, right?
Correct. The misdemeanors do not have guidelines.
And okay, and we don't do them for the high court misdemeanors either. So there are no guidelines. Is there anything you would like to say on behalf of your client?
Your Honor, when Mr. Hall, when the first case began, I guess I'll describe him as coming to almost, I call it a fork in the road, ones that he had in his life quite a bit. Mr. Hall is, I would say at this point, he has been really, I guess, forced to deal with the fact that his body is deteriorating from this alcoholism that he has been dealing with. He's been trying to, and I think as you can see in the PSI, he's doing really well and exceeding expectation at the Haven. He was in a really good spot. He was really motivated to deal with this. And again, his attitude when I was speaking with him was that he was addressing this. Now, obviously he is an alcoholic and he relapsed. Again, he was asked to leave the Haven. He was doing really well there. And again, I didn't do investigation. I don't know the exact details, but that being asked to leave sparked the relapse. He was doing really well. I think that he didn't want to leave there and that caused that issue. Again, he's been in jail now for 25 days or so since that issue happened. I think at this point, again, Mr. Hall is open to, he understands he's an alcoholic. Relapse is part of that. Again, he apologizes for that relapse. But I think in regards to this, obviously, I don't want Mr. Hall to have to be incarcerated any further for this. I think that Your Honor can be satisfied that he's not going to try to drink. He's expressed that he obviously with his health, he shouldn't be drinking at all. Obviously that incident happened. And again, I would say the alcohol had an extreme impact on him when he drank it this last time. And he's realizing that it's basically playing Russian roulette, I guess you'd put it that way, with maybe 2 bullets or maybe 1 or 2 opportunities left to play. And he knows that. So I don't think that Your Honor has to be concerned with him wanting to go out and go to a bar and drink or try to subvert the court's order or anything like that. I think he wants to engage in treatment. My only issue is obviously, I don't think he can go back to the Haven. Also, he spent quite a bit of time in inpatient treatment, and he was asking the court to consider placing him on an alcohol tether, having him on probation, having him engage in intensive outpatient treatment. There's restitution here for the damage done to the vehicle. Obviously, Mr. Hall, I was going to ask the court to consider reduced fines and costs. He's on a limited SSI. He wants to make good. He does apologize for his behavior. He doesn't want to make any excuses. He's not going to sit here and say, because I blacked out, that I didn't do any of those things. He obviously realizes that it's his behavior, the alcoholism, the drinking is what then causes. And you can see that's what causes any criminal behavior. He does have mental health issues he's been addressing. Again, the bipolarism, the depression that feeds into the alcoholism. So again, Your Honor, we're asking the court to consider that. Maybe seeing if you can do well with the alcohol tether and outpatient treatment. And if there is a, unfortunate another relapse, maybe then further inpatient. But at this point, that's what he's asking for, Your Honor.
All right, Mr. Hall, is there anything you'd like to say on your own behalf?
Yes, Your Honor. I'm embarrassed and ashamed of myself. My actions on July 3rd, loss of my control on September 15th, and my most recent relapse on April 8th. To the court, I am sorry and sincerely apologize. I know I'm not responsible for my disease, and I'm responsible for my recovery. So was not my intent to become somebody that I'm not when under the influence. It was not my intent to cause mayhem or harm to anybody. And I apologize. I know now that I will never be able to drink and have control. It is totally out of my hands with a drink. I am getting older, and I've wasted 40 years of my life drinking. And it is not worth looking at the jail, wondering what I'm going to say to you, wondering about where my life is going to go. It is not worth a drink anymore. I have finally figured out that I'm done drinking. I will not ever touch a drink again. In time, I prove that to this court. I ask that you give me a chance to prove myself. I just want to, I want to be productive in this community again. I have been productive in this community before, and I would like a way to give back, and that would be by helping others that go through the same struggles that I've gone through. If I could help one person not to drink and become like me, it would be all worthwhile. But I don't know. That's about all I got, Your Honor. I'm really sorry, and I hope that you're lenient with me. And that's it.
Anything else, Mr.
The kids. Oh yeah.
Nothing further, Your Honor. I mean, There is an outstanding issue with the contempt of court. I don't know, you want to address that,
I will.
but nothing further addressed here.
Okay, don't apologize to us. Your job security for me and Mr. Murphy. So you apologize to your family, you apologize, I'm talking, and you apologize to yourself, but I mean, you're the one that keeps us going. So it's time to make those changes in your life. You're 55 years old.
That's right.
And you're probably gonna die of this if you don't make some changes.
Yep.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, assurance against repetition by you and by others, potential for reformation, vindication for law, and protection of society. On file number 2025-22427FH, since the court will be placed on probation for a period of 2 years. I would like him to start out with an alcohol tether upon his release from jail. Can we do that?
We could do that, but we would have it do it one day.
Yeah. What, when he gets out of jail?
When he gets out of jail.
Okay. During your term of probation, you're not to use or possess any alcoholic beverages, can't go to bars, can't hang out with anybody who's drinking, not to use any illegal controlled substances or paraphernalia, complete any outpatient or residential substance abuse treatment when referred to by the field agent. If they order you to enter and complete another program, you're going to enter and complete, and you're not going to get kicked out this time. Do you understand that? Do you understand that if they send you to another program, you enter and you complete it, you don't get kicked out, okay? Say yes or no?
Yes.
Okay. You will serve 30 days in Lenawee County Jail. I'm going to give you credit for 4 days served on that file. There is a crime victim assessment fee in the amount of $100 and $50 in state costs. On file number 2025-22428FH, since the court will be placed on probation for a period of 2 years, same terms of probation apply. No contact with Erica Kier or Riverview Terrace Apartments, either directly or through another person. You can't be within 500 feet of her residence or Riverview Terrace Apartments. They can enter your house at any time if they believe that you have anything that would violate the terms of your probation or for supervision of your probation. You have to submit to a search of your person, your property, that's your phone, your computer, your car, wherever you're living. I'll give you credit for 4 days served in the Lenawee County Jail. On this file, there is restitution in the amount of $2,536. And that is to be paid to
Adrian City Police Department. Who was
that
Adrian Police Department.
To be paid to the Adrian Police Department. And then there is a crime victim assessment fee in the amount of $130, $30 per month supervision fee, $60 if we need to put a tether on you, and $118 in state costs. I'm not going to assess the $750 in court costs because you are on SSI, as well as you have a high restitution amount. And I'm more concerned about the victim being made whole or the Adrian Police Department getting their restitution. Anything else, Mr. Stevenson?
No, Your Honor.
Upon your release from the jail, the first business day, what are your instructions, Mr. Stevenson?
Report to our office.
Okay, these are misdemeanors, so obviously they run concurrent. Now, my bailiff's gonna hand down to, wait till I'm done, 2 copies of your notice of right to appellate review, 1 for each file. You're gonna initial and date 1 for each file for our records to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail them to the address listed on the form. Mr. Hall, people stand in front of me and say the exact same things you said today, and you've said them before. So this is it. You need to make sure you get a hold of this, okay? All right, now my bailiff's gonna approach with that.
John, I just wanted to make sure I heard it correct. He's got gave him 30 days with 4 days credit.
Is that for the contempt or?
No, I'm gonna dismiss the contempt of court.
Thank you, Your Honor.
So that's on, the 30 days is on file number 25-22427.
And just for the record, I want to make sure that then he didn't get credit, because he had a PR bond on his file then, right, since he was taken into custody on the contempt.
Did he have credit on that one? I thought it says he does.
Well, I mean, the 4 days credit is from before.
Yeah, he doesn't get credit for his contempt.
Okay, I just wanted to make sure we clarified that, so he understood what's going on.
All right, go ahead and sign that. Anything else, Mr. Stevenson?
No, Your Honor.
I don't see anybody here on Lopez versus Meredith.
I can look it up, Judge.
Huh?
I can look it up if you.
No,
want.
I just meant
Oh,
nobody's
okay.
showing up on it.
Okay, thank
So I'm gonna
you.
call it, because
Okay,
nobody's
Judge.
here.
All right, well, they've pretty much finished up on that. Good morning once again, everybody. TCF Live on a Super Friday, the 1st of May. So, because it's the 1st of May, today is Law Day, and Eric asked about what that is. The official definition, Law Day, celebrated on May 1st and throughout the month of May, has been a visible part of American legal culture since President Eisenhower established it in 1958 to celebrate the rule of law in a free society. There's always a theme, the 2026 theme, and these are established by the American Bar Association. The current theme is the rule of law and the American dream. So that is the theme for this year's Law Day. And a lot of courts hold like a talk or a ceremony or stuff like that, and that's why she was telling people to be back at 11 or whenever it was, is undoubtedly she's going to have words that she's going to say. So that's what that's all about. Okie dokie, let's do, what do we want to do? Let's do this. Let's go down to Florida and Wade Mercer.
Good morning, Mr. Ricardo. Would you please introduce yourself to Mr. Perez, Mr. Ramos Perez, and make sure he can see and hear you?
Yes, Your Honor. Good morning. I will. Señor Ramos Pérez, mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Great. Mr. Ramos Perez, you're here because you've been accused of one count of driving with no valid driver's license.
Señor Ramos Pérez está aquí porque tiene un cargo de manejar sin licencia de conducir válida.
You also have a failure to appear warrant in case 20-503
También tiene un caso de no comparecencia en la causa 20-503
And in that charge, you're accused of giving false information to law enforcement.
Y en ese cargo se le acusa de dar información falsa a un agente del orden público.
In addition to those two local charges, you also have a hold from the United States Immigration Service.
Además de esos dos cargos locales, también tiene una orden de retención del Servicio de Inmigración de Estados Unidos.
There is probable cause for your local charges, and I'm appointing the public defender's office to represent you.
Hay causa probable para sus cargos locales y le estoy asignando al abogado de oficio para que lo represente.
Please listen to your attorney, Mr. McDaniel.
Por favor, escuche a su abogado, el señor McDaniel.
Your Honor, I've spoken to Mr. Perez. He's going to enter a plea of no contest to the charges from last night and also no contest in 2503 MM.
Su señoría, he hablado con él y él se va a declarar no me opongo a los cargos que tiene, el de la licencia y también en la causa 20503 MM.
Understanding he's going to be sentenced to 60 days in the county jail with 1 day jail credit.
Entendiendo que se le va a condenar a 60 días en la cárcel del condado con crédito por un día.
They have a fine from last night's charges, will be a civil judgment, and a fine from, in case number 2503 MM of $370, which will be a civil judgment.
Tendrá una multa por el cargo de anoche de $400, que será un fallo civil, y una multa de $370 en la causa 20503, que será un fallo civil.
Signed his plea waiver form, waived his rights to jury trial, called witnesses, and understands that, and also understands that any plea can be used against him in immigration court.
Él ha renunciado firmando a su derecho a un juicio con un jurado y a llamar a testigos, y también entiende que cualquier arreglo o acuerdo en un caso penal puede resultar o afectarlo en su caso de deportación.
Thank you, Mr. McDaniel.
Y gracias, señor McDaniel.
Ms. Williams was just double checking the case number. Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Y señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
And Mr. Ramos Perez, did you hear that agreement?
Señor Ramos Perez, ¿pudo usted escuchar el acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
Si se puede, puedo pagar la multa.
If possible, I can pay the fine.
The fine has nothing to do with whether or not you would have to serve the sentence because of your history.
La multa no tiene nada que ver en cuanto a la condena que usted tiene que pagar debido a sus antecedentes penales.
So if you don't pay the fine, it may be referred to a collection agency.
Si no paga la multa, puede que esa se pase a una agencia de colecciones.
And your future driving rights may be suspended.
Y puede que su derecho de conducir en el futuro se le suspenda.
But it doesn't affect the jail sentence at all.
Pero no afecta la condena o el tiempo que tiene que cumplir en la cárcel en absoluto.
Do you have any other questions?
¿Tiene alguna otra pregunta?
No.
No.
Is this the plea you would like to enter, sir?
¿Es este el acuerdo que desea aceptar, señor?
Sí.
Yes.
Mr. Ramos Perez, I'm going to accept your plea of no contest to the following two charges.
Señor Ramos Pérez, acepto su declaración de no me opongo ante los dos siguientes cargos.
They are driving with no valid driver's license and giving false information to a law enforcement officer.
Manejar sin licencia de conducir válida y dar información falsa a un agente del orden público.
I judge you guilty of those offenses and sentence you to 60 days in the Jackson County Jail on each case.
Lo condeno culpable de los delitos y lo condeno a 60 días en la cárcel del condado en cada uno de los casos.
The sentences are running concurrently, which means one total sentence of 60 days.
Las sentencias transcurrirán simultáneamente, lo que significa que será una condena total.
You have credit for one day that you've already served.
Tiene crédito por un día que ya ha cumplido.
I'm imposing the court costs and fines of $400 and $370 respectively.
Le voy a imponer las multas y cosas del tribunal por $400 y $370 respectivamente.
Mr. Ramos Perez, when you get near the completion of your sentence, the jail staff will notify the immigration service of that and they will pick you up.
Señor Ramos Pérez, cuando usted esté acercándose a cumplir su condena, la cárcel le dejará saber a inmigración y ellos vendrán a recogerlo.
Do you have any questions?
¿Tiene alguna pregunta?
No.
No.
Have a good day, sir.
Que tenga buen día, señor.
Señor. Juan Lopez Domingo.
Sí.
Yes.
Mr. Domingo, good morning. Good morning, Mr. Lopez Domingo. You're accused of one count of giving false information to law enforcement.
Buenos días, señor López Domingo. A usted se le acusa de dar información falsa a un agente del orden público.
You also have a hold from the United States Immigration Service.
También tiene una orden de retención de parte del Servicio de Inmigración de Estados Unidos.
Your criminal history appears to show several prior removals from the United States.
En sus antecedentes penales se ve que se le ha removido de los Estados Unidos en varias ocasiones.
I'm appointing the public defender's office to represent you in the local charge and asking that you listen to your attorney.
Le voy a asignar al abogado de oficio para que lo represente en el cargo local y le pido que escuche a su abogado.
Your Honor, I spoke to Mr. Domingo. He's going to be no contest to the charge as listed.
Su señoría, hablé con el señor Domingo. Él se va a declarar no me opongo ante los cargos de los que se le acusa.
He sentenced 60 days in the county jail with 1 day jail credit, $370 fine, which would be a civil judgment.
Se le condenará a 60 días en la cárcel del condado con crédito por un día, una multa de $370 que será un fallo civil.
Understands that any plea can be used against him in the immigration court.
Entiende que cualquier acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
Waive his right to a jury trial and call witnesses at the trial.
Ha renunciado a un juicio con un jurado y a llamar a testigos en dicho juicio.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Gracias, señor McDaniel. Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
And Mr. Lopez Domingo, did you hear that agreement?
Señor López Domingo, ¿escuchó usted el acuerdo?
Sí.
Yes.
Sir, do you have any questions about that agreement?
Señor, ¿tiene alguna pregunta acerca del acuerdo?
No.
No.
Is that the plea you would like to enter?
¿Ese es el acuerdo que desea aceptar?
Sí.
Yes.
I'm going to accept your plea of no contest to the charge of giving false information to law enforcement.
Le voy a aceptar su declaración de no me opongo ante el cargo de dar información falsa a un agente del orden público.
I judge you guilty of that offense and sentence you to 60 days in jail.
Lo condeno culpable del delito y lo condeno a 60 días en la cárcel.
You have credit for the 1 day you've already served, and I'm imposing a fine of $370.
Tiene crédito por el día que ya cumplió y le voy a imponer una multa de $370.
Just like Mr. Ramos Perez, when you get near the completion of that sentence, immigration will be notified to pick you up.
Igual que el señor Ramos Pérez, cuando usted se esté acercando al cumplir su condena, se le notificará a inmigración para que lo recojan.
Any questions, sir?
¿Alguna pregunta, señor?
No, ya no.
No, that's it.
Have a good day, sir.
Que tenga buen día, señor.
Thank you, Mr. Ricardo.
Thank you, Your Honor. Have a good day.
You too. We have State versus Gregory Andrews and Arthur Williams.
Hope y'all come on.
Mr. Andrews and Mr. Williams, good morning.
Good morning,
Which
sir.
one of you gentlemen is Mr. Andrews?
I am, sir.
Great. And that means the other gentleman, you're Arthur Williams, sir?
Yes, sir.
All right. So I'm seeing you at the same time because your cases are identical for this morning's purposes. Each of you are accused of violating the terms of your state probation. In each case, the circuit judge has signed a no bond warrant. So I'm simply going to arraign you this morning because I want to get you a lawyer appointed to represent you if you're asking for one. In addition to your Jackson County charge, Mr. Andrews, you also have the same charge in Bay County. So you have a hold from Bay County with no bond for violation of probation. Mr. Andrews, would you like to have an attorney appointed to represent you in Jackson County?
Yes.
Great. And Mr. Williams, same question.
Yes, I would like an attorney.
All right. I'm going to appoint the public defender's office to represent both of you. Listen to Mr. McDaniel, and then we'll see if you have any questions in just a moment.
Your Honor, we're going to enter not guilty as it said these on the June 7th pretrial, June 4th pretrial docket, and I advised them there'll be an attorney from the public defender's office that'll stop by and speak to them about the case prior to that hearing.
Thank you. Mr. Mitchell, anything from the state?
Just one thing right quick, and this is kind of to Mr. McDaniel. I believe originally with Arthur Williams, the PD's office had the conflict on his case for something. I may be wrong, but I think I remember he's not in agreement. So you may want to talk to possibly the conflict office.
They'll review it, and if it is, they have to file a motion. So I mean, we got to get it pointed to us before we can actually conflict off.
Okay, I just wanted to bring that to your attention.
So for now, the public defender's office has both your cases, gentlemen, and we'll see what happens from there. Mr. Andrews, do you have any questions?
Yes, sir.
Wish you the best, sir. Mr. Williams, do you have any questions?
Yes, sir.
I couldn't hear. Did you say yes or no?
Yes, sir.
Okay, go ahead.
I was under prison on this case, so I couldn't report. Feds picked me up.
I'm taking a look at the warrant. It's signed March of 26. What you're accused of doing is violating 4 conditions of your probation. Number 1 is financial. Number 2 is financial. Number 3 is not doing anger management. And the fourth one is not doing community service. So give me the timeline from you were sentenced in October of 24. Well, no, I'm sorry. That's when you were sentenced. So you went to federal prison directly from state court. Is that what you're saying?
Yes, sir.
Yes, correct.
Okay. And you were in custody that entire time until when?
Yes, sir.
Until when did you get out of federal prison?
I had a knee surgery March 2nd and got out March 4th. I was in the halfway house.
Mr. McDaniel?
Yeah, I was going by the jail. I thought they got transferred here from the feds, but I guess what he's saying is he was at a halfway house. I guess.
I was on Lake Montage.
And you
Lake
came
Montage.
directly from the halfway house?
Huh?
When did they remove the leg monitor from you?
They moved the leg monitor after the surgery on the 4th. They came to my house and moved it. And the federal probation came to my house too.
They bring you over here when?
They brought me over here the 20th. I got arrested the 20th, one to report in for federal for the first time. After my surgery. I had a knee replacement.
Okay. So what I'm going to do is this, Mr. Williams, Judge Garcia signed this warrant on March 16th. There's a chance that she wasn't aware of everything you just said. I'm going to ask Mr. McDaniel to try to notify. I'm not sure if Mr. Green was out on medical situation, Mr. McDaniel. So you may want to notify Mr. Sims, whoever you decide to notify, and make them aware of this. This needs to be a case that needs to go back before Judge Garcia today. Someone needs to go to Judge Garcia today and say, Judge, were you aware of this? Because that may affect what Judge Garcia does in this case as far as the warrant, whether or not it's a bond, whether or not it's a notice to appear and so forth. I'm not going to modify another judge's warrant under these circumstances, but I do want her to be aware of it. So I'm going to ask Mr. McDaniel's office to try to do what he can to make the public defender's office aware of the unique situation, because someone needs to go to Judge Garcia today, if at all possible, and let her know what's going on. So that may not change her mind because you were out for some period of time, but the first time you reported in is when you were arrested, correct?
Yes.
So it certainly could change her mind. But with Mr. Green being out on a medical situation, I don't know what else to do.
Mr. Blunt or Mr. Sims will get in touch and probably handle his VOP case.
If he is still there Monday, if nothing's happened Monday, I need to have him brought back up so I can take another look at it. Mr. Mitchell, I'm going to ask you to talk to, from your end, to investigate it for Monday. That way, if he's still there Monday, I'll know whether or not the state is asking that he be held.
Yeah, that's what I'm looking at. And
it may be your case now. You may know.
It is my case because it looks like it's technicals, but I don't know. It's just strange to look at, but I'll look into it a little bit more.
So Mr. Mitchell will be the prosecutor in that VOP case. So he's also going to take a look at it. So if you're not if you're not released today, I'll see you on Monday and we'll get a more complete answer, but you may get out of jail today. If the state's in agreement, if you look at it, you're in agreement with letting him out, then y'all need to go ahead and let me know. I'm not sure what Judge Garcia's schedule's like today, but
I'll go talk to Debbie after first appearances and see what she's doing.
Okay. Sounds good. So if you're not out today, I'll see you Monday, Mr. Williams. There's a chance you'll get out today once Judge Garcia gets the rest of the story, okay?
Yes, sir. Thank you.
Have a good day, sir. You're welcome. Next case is John Wilson. Mr. Wilson, good morning. Mr. Wilson, you're here for first appearance accused of 15 counts of possession of child pornography. You're also accused of 1 count of unlawful use of a two-way communication device. Mr. Wilson, it also appears that you're on probation for lewd and lascivious. I've read your criminal history. I've also went back and I read that lewd and lascivious complaint from Marion County. So I'm aware in that lewd and lascivious complaint, there were allegations of at least 2, possibly 3 other prior incidents that were alleged in that complaint involving different children. So there's a lot there, Mr. Wilson. I'm going to listen to the attorneys and I'm going to set your bond. Mr. McDaniel, anything on behalf of Mr. Wilson?
No, Your Honor.
Mr. Mitchell?
You pretty much said what I wanted to say about the BOSP in Marion County. I guess we would just request that I only can't have unauthorized internet access anyway. We'll leave the extra conditions up to the court.
Mr. Wilson, the possession of child pornography, if you have more than 10 counts in Florida, they become second-degree felonies instead of third. Since you're accused of 15 counts, that increases your degree of your crime, which increases your bond. Your bond's going to be $25,000 on each count. There's 15 of those. You got a bond of $375,000 on the child pornography plus $10,000 bond on the unlawful use of two-way communication device. That makes your total bond $385,000 cash or surety. Do not try to post the bond because I'm going to hold you for 7 days with no bond and ask Mr. Mitchell to notify the probation office of your arrest. They have 7 days to seek a warrant from the judge in Marion County. I have no idea if they'll get one or not, but I'll see you in 7 days and we'll see if they have a warrant. If they have a warrant, that judge will decide if you get a bond on that or not. If they don't have a warrant, Mr. Wilson, then I'll release that hold and you have the right then to post the bond here. The bond here does have a condition of no internet access at all, given the nature of your charges. Mr. Wilson, I'll see you in 7 days. You will get to use the phone in a few minutes, sir, to contact friends or family. Do you have any questions? No? All right. Have a good day, sir.
All right.
We have Kyle Cook. Mr. Cook, good morning, sir. You're here because you've been accused of 1 count of driving while license suspended or revoked knowingly. There's a real question about whether you're on probation or not. The best I can tell, you may have got off probation yesterday. I'm not sure. So,
Everything paid.
Sir?
I paid everything, all my community service hours done. I got off yesterday. It ran out. And he said he charged me with driving.
Just a second. Let me deal with it one at a time. I think that may be accurate. You may have gotten off yesterday. Mr. Mitchell, is the state asking that he be held, given that he may have gotten off yesterday?
Given that it looks like he got off yesterday, we're not asking that he be held. Okay. And given what the nature of the new offense is.
Great. So, Mr. Cook, that only leaves the driving while license suspended or revoked then, which I think you're entitled to a bond on. You do have one of those within the last year or so. So that's going to affect the bond. Your criminal history also is pretty lengthy. So I'm going to listen to the attorneys and I'm going to set your bond in that charge. Mr. McDaniel?
Our 22 insurance on that.
Your Honor, we just, I mean, obviously he's disagreeing with the charge as far as knowingly driving, but but we're just asking for a bond. I mean, he did have a driver's license and had his 22 insurance. And,
paid all that, and they pulled up to the office.
I guess he's suspended, if I recall, for not paying a fine, and I guess he's paid off that fine, maybe, possibly. I'm not quite sure. So he probably just has to go get a reinstated.
Let me see if he got it back since the last one, because that's going to affect the bond, because I remember he had one pretty recently, and I was under the impression he never got it back. But let me double check that.
They had me holding this SR 22 insurance. That's the last thing they told me. That's what I was trying to tell him when I give him my license. The officer, I was like, sir, I'm not trying to lie to you. I mean, I said, I understand. He's like, well, because he said that I had a bunch of priors. And I said, I understand that. I said, but I'm not trying to lie to you because I got a letter in my car where I had to hold the insurance that I got from the DMV in the courthouse and paid off all my fines.
So you received one of these, the same charge. You got it last year in January, but you resolved it in September of 25, according to your driving record. And your driving license was suspended after that. Your driving record was suspended September 22nd. You resolved it September 12th. So yeah, that's what it looks like. So I think he got one. He got his license fixed.
I just got that insurance stuff. I think
there's some more suspension. Well, there's some financial response. There's some other suspensions out there that it looks like you haven't paid reinstatement fees on. So I'm not sure he did get his license back, but it's going to be a normal bond anyway. Mr. Mitchell, anything?
No,
Mr. McDaniel, anything else?
No, Your Honor.
Mr. Cook, your bond's $2,500 cash or surety. You have a condition not to drive a motor vehicle without a valid license. That's a special condition to your bond, and you'll get a chance to try to post that bond. You'll get a chance to use the phone in just a minute. Mr. Cook, the jail will also give you a notice for your court date, which will be June the 1st at 9 a.m. I don't think I asked the jail to give a notice to Mr. Wilson for his court date. We need to do that also, which will be June the 2nd at 8:30. So, Mr. Cook, you'll get a chance to use the phone in a few minutes. It's cash or surety bond, which means you don't have to come up with all $2,500, and you'll get to use the phone in just a few minutes. Any questions, Mr. Cook?
Do y'all take that bond right here at the jail?
You can. If you have all $2,500, they'll take it there. Otherwise, you contact the bondsman.
Yeah, if I can just get to my wallet and use my debit card, I got it.
They'll talk to you about that, okay?
Okay, yes, sir. Thank you.
Sir. Yes, sir. After Mr. Cook, we have Jason Pollock. Mr. Pollock, good morning. Mr. Pollock, you're here in case 26-175 and 174, one count of trespass and one count of petty theft. I was advised this morning that the petty theft count also has an accompanying trespass that somehow was not set up, was skipped by someone in the clerk's office. But I think Mr. Mitchell and Mr. McDaniel have got that case, got an agreement to dismiss that count. Listen to your attorney. I'm appointing that officer to represent you.
Let me, so Your Honor, we're going to have no contest, case number 26-174, 26-175, 26-174. They're going to dismiss the trespass it'll be pleaded to a petty theft and a trespass charge. 90 days in the county jail, run concurrent, 1 day jail credit, $370 fine in each case. Hopefully work it out while it's in trustee bay. That'll resolve this case today. He has signed his plea waiver, waiving his right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. We would request that he be adjudicated guilty.
And Mr. Pollock, is that, any questions about that, Mr. Pollock?
Yes, sir.
Mr. Pollock, is that the plea you would like to enter?
Yes, sir.
Mr. Pollock, I'm going to accept your plea of no contest to these two charges, 26-174 MM and 175 MM, petty theft and trespassing. A judge you guilty, the state's dismissing the second trespassing, sentence you to 90 days in jail on each case concurrent for a total sentence of 90 days, 1 day credit on each case, $370 court costs and fines. In each case, no probation to follow. It's just a jail sentence, Mr. Pollock. And Mr. Pollock, when you finish this sentence, you'll be released. There's no probation at all in this sentence. Mr. Pollock, you certainly may get some extra game time under Florida law. I would encourage you to look into the trustee program at the jail if that interests you. Any questions, sir?
No, sir.
Have a good day, sir.
Yes, sir.
Nicholas Eubanks.
Well, the next contestant comes up earlier this morning. Tim, 5 gifted memberships. Thank you for that. And Wahoo just now, thank you for gifting a membership as well.
I'm going to appoint the public defender's officer to represent you, tell you there is probable cause for the charge, and I have looked at, refresh my memory on your criminal history since I saw you about 2 months ago for the same thing. I'm going to appoint the public defender's officer is appointed. Please listen to Mr. McDaniel.
Your Honor, I spoke to Mr. Eubanks. He's going to plead no contest. The charge is listed. Understanding he'll be sentenced to 90 days in the county jail, 1 day jail credit, $370 fine, reserve and restitution, and he's signed his plea waiver form, waiving his right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. We're also requesting he be adjudicated guilty for this count, and I guess he be notified that if he's caught going to Walmart again and doing the same thing, it'll be a felony next time.
Mr. Eubanks, I think I may have told you that last time, that your third one can become a felony. Now you have 3 after today. So this will actually, the next one will be a 4th. If you get charged with this again, it's possible to go to felony court. So just, you need to be aware of that. Mr. Eubanks, any questions about this agreement?
No, sir.
Is this the plea you would like to enter, sir?
Yes, sir.
Mr. Eubanks, I'm going to accept your plea of no contest to the charge of retail theft, 2 counts. A judge will guilty of those first-degree misdemeanors. Sentence you to 90 days in jail on each case concurrent, so they're running at the same time. You've got 1 day credit on each case, $370 court costs and fines imposed in count 1. I'm going to reserve jurisdiction for 60 days for restitution purposes. If the state wants restitution, they have 60 days to schedule and conduct a hearing. If you don't agree to that amount, I don't know if there's restitution or not. Frankly, I can't tell from the complaint. It looks like there may be restitution on 1 case and not the other. But Mr. Eubanks, you've gone from no history to 6 months ago. Now you've got You've got 3 misdemeanor convictions. Unless you change something, Mr. Eubanks, I'm afraid you're headed down a bad path. Do you have any questions, Mr. Eubanks?
No, sir.
Wish you the best, sir.
Your Honor, for purposes of restitution, can I see the complaint again?
Sure. There's a second incident. The complaint, I'm not going to say it's not drafted well. It's just rather confusing. They get called about an incident. He's on video, and then they get called back for a second incident, and the second was the one they actually make the arrest on initially. So, Mr. McDaniel, we also have State versus Sandy King. Is that Mr. King here with us?
Yes, Your Honor.
Okay. This is Mr. King. You're here in case 26-22 CT. Mr. King, Mr. McDaniel filed a written motion. He's trying to get you out about a week or 10 days early for your daughter's graduation. So listen to your attorney, Mr. McDaniel.
Your Honor, I just made one mistake in everything. It's not his daughter, it's his son. I just.
Okay.
Your Honor, we just asked the court, a written motion was for May 22nd because he's going to graduate May 23rd. The mother emailed me last night, and not the mother, his wife emailed me last night. Said she's going to be out of the country, has got to fly out on the 23rd. And was asking if it would be possibly the court would let him, maybe possibly let him out on the 21st. He's been here for, he's been a good trustee here at the jail. He's done everything he's asked to done. It wasn't a major crime here. It wasn't anything here that, where it's any kind of crime of violence or anything like that, Your Honor. We'd ask the court to consider, go ahead and releasing him that week or 10 days early so he can go to his son's graduation on that 23rd. Hopefully get him out of the 21st.
Thank you. Mr. King, yesterday when we talked about this case, excuse me, with the jail told us, the jail staff told us, I think it was Sergeant Gross, that you had no DRs and that you've been a model inmate the time that, the couple of months you've been out there. That is a factor. If you do get out, are you going to go to the graduation, Mr. King?
Correct.
And the request is to be released on May 21st. Mr. King, you need to understand this request is conditional upon you staying, excuse me, upon you staying in the trustee program. Would you see if there's any water in that refrigerator, please? In other words, if you get in trouble and you violate rules of the trustee program and you lose gain time that you've got right now, you've got some gain time earned. But if you lose any gain time by getting in trouble at the jail, that would nullify this order I'm about to sign. You understand that?
Yes, sir.
Mr. Mitchell, will stay position.
They have no objection to the request and we're okay with the order being signed.
Okay. So, Mr. King, I'm going to sign this order granting early release. You're going to be released on May 21st, as long as you have no violations. Thank you. That are going to, as long as you don't have no violations of the jail program that would cause you to lose trustee status or forfeit gain time. I just signed the order. So you'll be released May 21st. So wish you the best. And so you can go to that graduation. Mr. King, do you have any questions?
No, sir. Thank you.
Yes, sir. Wish you the best. I think the original release date was June 1st, based on what I was told yesterday. So, Mr. McDaniel, that's everything I had on the first appearance docket that I'm aware of. Anything else from the public defender's office?
Alrighty, that wraps it up for Judge Mercer. Once again, everybody, good morning. It's a Super Friday here at TCF. If you are new out there in the chat, out there in the world, new to the channel, kindly say good morning to us. We would love to hear from you. Let's do something new. Let's go to Highland County, Ohio. This is a little bit east of Cincinnati. This is Judge Rocky Coss. I have not watched his stuff before, but he will win the award for the most interesting judge's robe. Lindsay, thank you for gifting 5 memberships. I very much appreciate that.
Okay, this is case number 25, CR169, State of Ohio versus Christopher L. Rump. Present for the states, Assistant Prosecutor King and Intern Willie. Present on behalf of defendants, Attorney James Bolden. You're Christopher L. Rump?
Yes, sir.
All right, the defendant is charged in a 3-count indictment, having weapons under disability, aggravated possession of drugs, and a forfeiture. We will have a trial date of May 14th. The matter is set today for a plea and to request of the parties. I've been presented with a plea of guilty form. Indicates that the defendant is going to plead guilty to all 3 counts. And I'm looking at this agreement, Mr. Rump. On page 3, there's a sentence that reads, "Enter this plea voluntarily." Right below that, there's a line for signature defendant. There's a little X next to it, and I see Mr. Boulder's signature below. And is that your signature on this document I'm looking at?
It is, Your Honor.
When did you sign it?
This morning, Your Honor.
Just a quick pause. Ashley, thank you for gifting 10 memberships. You guys are being very generous this morning. I sure appreciate it, and I know the community does too, so thank you. Back to Judge.
All right. When you signed this document, did you understand that it was an agreement to plead guilty, meaning there won't be a trial, and the next step in your case would be a sentencing hearing?
I did, Your Honor. And
when you signed this agreement, is this what you expected it to be from your previous conversations with Mr. Boulder?
Yes, Your Honor.
So you were not surprised by this, the content of the agreement?
No, Your Honor.
And you feel that you had enough time to fully consider the matter before making the decision to sign this agreement?
Yes, Your Honor.
And did you sign it voluntarily?
I did, Your Honor.
All right. And are you going forward today with the plea voluntarily?
Yes, Your Honor.
All right. So the agreement says you're going to plead guilty to the 3 counts in the indictment. Count 1 is having weapons while under disability in violation of section 2923.13A3 excuse me, of the Ohio Revised Code. Count 2, aggravated possession of drugs under section 2925.11A of the Ohio Revised Code. And both of those are 3rd-degree felonies. And then the forfeiture specification is under 2941.14.17. And it is a forfeiture of property. It does not carry any additional penalty other than the loss of property. Counts 1 and 2 are both 3rd-degree felonies, so there's a possible sentence of between 9 and 36 months of incarceration in prison on each of those, and a fine of $10,000. The second count has a mandatory fine of $5,000. If you are convicted of both offenses and sentenced to prison, then the sentences could range anywhere from 9 months as a minimum up to 72 months as a maximum, because they could be ordered to be served consecutively, and you could have fines totaling $2,000. Do you understand that?
Yes, sir.
Now, with regard to count 2 only, there's a presumption prison should be imposed, but it's not required. Do you understand that?
Yes, sir.
Now, other than these charges, Mr. Rump, are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, post-release control for a felony?
No, Your Honor.
Now, under the law, if you are sentenced to prison on these offenses and serve a prison term, upon completion of that term, it is possible that the adult parole authority would exercise the option to put you in what's called post-release control supervision for a period of up to 2 years. That means you would be supervised by a parole officer on the terms they set. And if they determine that you have failed to comply with those conditions, they have the authority under the law to return you to prison as a sanction, even though you've already served the entire prison term set by the court, for an additional period of up to 9 months for a single violation. There is a cap or limit of half of whatever the actual prison term imposed by the court was for all violations. If, however, you are convicted of a felony while on post-release control supervision and are sentenced to prison for that, then that judge is also authorized to sentence you for committing that offense or under post-release control in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, I'm not required to sentence people convicted of these offenses to prison. So the law does provide then that you could be sentenced to what's called community control or probation. And that means instead of being sentenced to a prison, you'd be put under the supervision of a probation officer on a term set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not complying They would file a written notice of that with the court. There would be a copy given to you. You would have a hearing of which you would be entitled to have an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your committee control and could sentence you to a period of between 9 and 72 months incarceration and fine you $20,000. And if the revocation of your committee control was due in part or whole because you had committed a new felony while under community control and were sentenced to prison for that offense, the sentence in that case, in this case, could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes, sir.
All right. Now, the first count in the indictment alleges on or about October 30, 2025 in Highland County, Ohio, that you, not having been relieved from disability as provided in section 2913.14 of the revised code, did knowingly acquire, have, carry, or use a firearm. And at the time, the said Christopher L. Rump had been convicted of a felony offense involving the illegal possession, use, sale, administration, distribution, or trafficking in any drug of abuse, to wit, aggravated possession of drugs, on April 30, 2014 in Claremont County Court of Common Pleas in case number 2014-CR-00164 in violation of section 2923.13A3. Count 2 alleges that on or about October 30, 2025 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule I controlled substance, to wit, psilocybin, an amount that equals or exceeds the bulk amount but is less than 5 times the bulk amount, in violation of section 2925.11A of the Ohio Revised Code. And then count 3 alleges that on or about October 30, 2025 in Highland County, Ohio, you had in your possession a High Point model JHP 45 ACP serial number X4357720, subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined in section 2941.14.17 of the Ohio Revised Code. So those are the 3 charges that we've talked about. Now, Mr. Rump, do you understand what it is you've been charged with in each of those counts, what the state said you did, when, where, and how they alleged that you did?
I do, Your Honor.
Have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, the possible defenses you may try to raise at trial, and the possible outcomes of a trial with your attorney?
I have, Your Honor.
And are you satisfied with his advice and competence in this matter?
I am, Your Honor.
Has anyone, or are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No, Your Honor.
Page 2, there's a couple of lines printed that read as follows. Defendant will enter a plea of guilty to the indictment. State defense will argue sentencing. Defendant agrees to forfeiture in count 3. Is that your understanding of the agreement?
It is, Your Honor.
No one's promised you anything other than that to get you to plead guilty?
No, Your Honor.
So you don't, you've not been promised by anyone that you'll receive a particular sentence if you plead guilty?
No, Your Honor.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, Your Honor.
Now, you have certain constitutional rights, let's understand, before I can accept the plea. You have right to counsel, and you've employed Mr. Bolger to represent you. If you were unable to pay to have an attorney or to continue to pay him, then the court would appoint counsel for you at no cost. So the reason I mention that is I've asked this question: are you entering into this agreement because you are afraid you're not going to be able to afford to pay Mr. Bolger to continue to defend you?
No, Your Honor.
Now, you have a right to have a jury trial in the case on all 3 counts, which means that a jury of 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence is presented, and then the judge instructs them on the law. And then that jury decides by a unanimous verdict, meaning all 12 would have to agree as to whether the state proved your guilt in any of the 3 cases. And again, it has to be unanimous in each case, in each count. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, in which case you would have what's called a court or bench trial. And that means that instead of a jury, it's the judge who hears the evidence, applies the law, and decides whether or not the state proves your guilt. You understand that?
Yes, Your Honor.
Now, under law, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is the witnesses against you have to appear and testify in open court in front of you and your attorney and anyone else is observing. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Now, under the law, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. That means that if you have witnesses you're not certain are going to appear or can appear voluntarily, that upon your request in writing, the court issues a subpoena, which is a court order that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes, sir.
Now, under the law, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. And if you decide not to testify, the fact that you did not testify cannot be used in any way by any person during the proceedings, and in fact, no one's even allowed to comment on it, with one exception. If there is a jury trial and you just elect not to testify, the court instructs the jury that because it is your constitutional right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the law, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of each of the offenses charged. So what that means is the burden of proof isn't on you to try to prove you're not guilty of any of these charges simply because you've been indicted and accused. In fact, under the law, you're not required to present any evidence at all in your defense at trial. You are permitted to do so, but you're not required to. But whether you present any evidence in defense or not, the burden of proof stays on the state of Ohio to prove your guilt on each of these three counts, and they have to prove each essential element of each of those counts by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. And again, the verdict on each would have to be unanimous as to each count. Now, do you understand that?
I do, Your Honor.
All right, now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've described before you. If you change your plea from not guilty to these three charges, that is the opposite of the not guilty. The guilty plea would admit the allegation in each of the three counts, admit that they're a crime in each count, and admit that you committed those crimes. And that plea would waive and give up all of the rights that I've described for you today, except your right to have counsel. You always have a right to have counsel no matter what your plea. But without exception, your plea of guilty would waive and give up your right to a jury or court trial. It would waive and give up your right to confront witnesses against you and to cross-examine them in open court through your attorney. It would waive and give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. It would waive and give up the privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive and give up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove your guilt on any of the three charges. It does subject you to being sentenced immediately by the court. Finally, it waives and gives up any right to file an appeal that you think you may have had up until this point in the case. Now, should you be sentenced to the maximum sentence or under other limited circumstances, an appeal could be filed. That appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Rump?
Yes, sir.
All right, now, do you have any questions about the charges or the possible penalties?
No, Your Honor.
You understand them?
Yes, Your Honor.
Have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, Your Honor.
Have any questions about the constitutional rights I've explained?
No, Your Honor.
Do you understand those?
Yes, Your Honor.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, I do.
Is there anything you need to speak to Mr. Bolger about before we go any further?
No, Your Honor.
Do you have any questions at all?
No, Your Honor.
All right, then is it your decision to withdraw your not guilty plea and plead guilty to the three counts of the indictment pursuant to the terms of this plea agreement that we've just gone over?
Yes, Your Honor.
And you do that voluntarily?
Yes, Your Honor.
All right, then as to the charge in count one, which reads that on or about October 30, 2025 in Huntington County, Ohio, You not having been relieved from disability as provided section 2923.14 of the revised code, did knowingly acquire, have, carry, or use a firearm, and at the time you had been convicted of a felony offense involving the illegal possession, use, sale, administration, distribution, or trafficking in any drug of abuse, to wit, aggravated possession of drugs on April 30, 2014 in Claremont County, Court of Common Pleas in case number 2014-CR-00164 in violation of section 2923.13A3 of the Ohio Revised Code, the charge of having a weapon while under disability, third-degree felony, carrying a possible penalty between 9 and 36 months of incarceration and a fine of $10,000. How do you plead?
Guilty, Your Honor.
As to count 2, which alleges that on or about October 30, 2025 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule I controlled substance, to wit, psilocybin, in an amount that equals or exceeds the bulk amount but is less than 5 times the bulk amount, in violation of section 2925.11A of the Ohio Revised Code, a third-degree felony, carrying a possible prison term of between 9 and 36 months, a fine of $10,000, mandatory fine of $5,000. How do you plead?
Guilty, Your Honor.
Then as to count 3, that alleges that on or about October 30, 2025 in Highland County, Ohio, you had in your possession a High Point model JHP 45 ACP serial number X4357720, subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined in section 2941.14.17 of the Ohio Revised Code, which would result in the loss of that firearm to the state. How do you plead?
Guilty, Your Honor.
All right, the court finds that on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Plea is accepted and ordered filed. Defendant is found guilty of each of the 3 counts. The matter is referred to the Probation Department for a pre-sentence report, which will include an assessment for substance use disorder and/or mental health. I know at our previous conversation, Mr. Bolger he indicated he wanted to apply for drug court, so when he meets with the probation officer, he can request that application. We will set the sentencing for June the 10th at 9 a.m. if you're available, Mr. Bolger.
I am.
All right. All right. That'll be June the 10th at 9 a.m. in person. Bond will be continued. So you see Mr. Searchers over here that set up an appointment for you for your pre-sentence interview, and your if you decide to request application to the drug court docket to meet with the drug court coordinator.
Yes, sir.
Is there anything further, counsel? There, Your Honor. All right. Thank you. Thank you.
Okay, friends. So I got to looking at that judge's robe, and I had a suspicion. So I did a little digging. And Judge Coss received a BA in history from Ohio State University in 1973 and his Juris Doctorate from Ohio State University Moritz College of Law in 1975. Friends, he's wearing OSU colors. That's why that robe is red and gray. It's his university. So that explains that. Now, Gigi said that the courtroom had a court-like or a church-like feel to it. Well, there is the court building right there, my friends. Now, this is actually an interesting place. This is the Highland County Courthouse. It's in Hillsboro, which is the county seat for Highland County, Ohio. Again, that's a little bit east of Cincinnati. It is on the U.S. Register of Historic Places, just like the courtroom that Middleton is in now, just like that building. This was built in 1834, and it is the oldest courthouse still in use in the state of Ohio. So that's why it's got that old-timey church-like kind of feel, friends. It's, I mean, that's the architecture back in the day. That's how they built these things. And they're still using that. You know, it's coming up on 200 years old almost now. And they're still using that courthouse. So very cool. So thought I'd share. I'm sure we'll pay another visit to that court at some point in the future. Let's go back to Michigan, though, and Judge Anzalone. They're going to do a motion in limine. So let's see what that one's all about.
Mr. Kara?
Yes.
Okay, all right, and I always see you guys on Zoom, so, and then I have Corey Tomlinson and Kayla Henderson appearing on behalf of the defendant. And this is the date and time scheduled for multiple motions. So we can start with defendant's motion in limine to preclude reference, evidence, mention, or allusion to marriage between Pardeep Saini and Nicole Obenauer at trial. So let's start with that one.
Thank you, Your Honor. Do you prefer?
Yeah, yep, and make sure you speak loud.
Okay. So defendants are moving to essentially effectuate the court's prior order from September 15th that ruled on partial summary disposition that the plaintiff and the decedent Nicole were not formally legally married, and therefore the plaintiff cannot recover those damages on his own behalf under the Wrongful Death Act, and that was a concession that there was no legal marriage. There's been continued reference in discovery to these two individuals as spouses, and this motion in limine is essentially to prevent that misrepresentation from happening to the jury via visuals, reference, or testimony. I think this is not meant to insult the relationship between the decedent and the plaintiff, but it's being mindful of the legal terms and their implications. Marriage is a civil contract that comes with those duties, rights, and responsibilities. And it's not something that you can just enforce because it wouldn't have been too difficult to sign the paper that creates that binding relationship. The two parties themselves were aware that they did not enter into a relationship with records showing that they referred to each other as a boyfriend or girlfriend, and that they represented in legal filings that they were single. What the family labels the relationship is not material. Family can discuss their relationship and the loss of the decedent Nicole independent of her relationship with the plaintiff. They can use photos of Nicole not at a wedding, not emphasizing a ceremony or a reception that would lead the jury to believe that there was a marriage. That would be misleading and confusing to the jury, and that is sufficient to allow an exclusion of that evidence under Michigan Rule of Evidence 403. When there's a danger of confusing the issues or misleading the jury, that should be excluded when it substantially outweighs any nominal probative value. We're not asking the court to pretend that these two did not have a meaningful relationship, a lifelong partnership, but to call it a marriage would just be legally incorrect and misleading. So, thank you.
Mr. Kara.
Thank you, Your Honor. First of all, it's a pleasure being here in person today. I always see you on Zoom. Counsel is correct in that this court did rule that Mr. Saini cannot claim damages individually for the death of Nicole Obenauer. And
if you could just speak up a little bit. It's very outdated recording system here. I apologize.
Please let me know if this is okay. Perfect. Thank you. All right. So counsel is correct. Mr. Saini is not going to be claiming damages individually under the Michigan Wrongful Death Act, and this court has already entered an order in. Although I disagree with what the law says, I respect this court's ruling where we are not going to be asking the jury to award those damages. However, it is a fact, it is the truth that both of them were married. Attached as Exhibit 1 is a marriage certificate that talks about, where they got married, when they got married, who attended. 75 people attended this marriage, including the family members. Nicole's mom is here, Nicole's dad is here, sisters, everyone, and they all testified that they were both, everyone that attended considered them to be married, including defendant's own hospital records that they have attached in their motion, references to Mr. Saini and Nicole as husband and wife and spouse. So at trial, what we are going to say to the jury is there was a religious wedding ceremony. but they did not obtain a county license. We are not claiming damages for Mr. Sani, but there are other members within Ms. Obenauer's estate, the parents, the sister, and the son, which Mr. Sani and Nicole had a son, Dilraj, who's 6 now. They're entitled to claim those damages. They attended that marriage ceremony. They attended that event. They have emotions attached to it. So with the loss of Nicole, they get to claim those damages. It goes to the emotional damages and the loss of society, companionship, everything else under Michigan Civil Jury Instruction 45.02. So we're not going to come out in our opening statement or with evidence and suggest that they had a lawful marriage. What we plan on saying is that they had a religious wedding ceremony that everyone attended, but they did not obtain a license from the county subsequent to the marriage. They do have a marriage certificate from the religious institute where the marriage took place. And this court can, in fact, with some sort of special curative instruction, inform the jury of that. But to take away what their relationship meant to them and what it meant to their family, I think would be disrespectful not only to the decedent, but the way the family and Nicole and Pradeep looked at each other and behaved in public's eye. So for those reasons, I think this motion should be denied. And this is something certainly that can be corrected by way of a special jury instruction that we can all probably craft ahead of trial. Thank you, Judge.
All right, thank you.
Just briefly, Your Honor. The religious recognition of a marriage is different. As we know, there's much fight over the right to call someone their spouse and being married under the law. That's something that's been a longstanding legal doctrine, and we are not intending to disrespect their union, but to mislead the jury with permeation of the idea of a marriage would just be improper because it would be confusing and misleading to them. And a curative instruction would only be one piece, but continued reference through multiple family member testimony and visuals and argument and references essentially the entire trial to each other as spouse would just be improper because it's not legally correct. So defendant requests that the motion be granted. Thank you.
Thank you. So obviously there was a prior ruling, but the purpose for that prior ruling was different than this. Exhibit 1 does show that these parties did enter into a religious ceremony. I think a lot of people do that. I had a religious ceremony as well as a civil ceremony, but I don't think that we should diminish the religious ceremony that the parties had in full accordance with their Sikh religious customs and protocols. So I am going to deny the motion in limine, and she can be referenced as a wife at trial because obviously it's spiritual marriage, and whether it's legal or not, I think can be resolved with a curative instruction. So I will deny that motion. All right, so moving on, I have there we go. Do you want to do, well, there was a defendant's motion in limine to exclude non-economic damages on behalf of plaintiff's decedent fetus at trial. Do we want to move into that one? Okay, so you may proceed.
Thank you. I'd like to clarify that the motion is not to exclude the entire category of non-economic damages on behalf of the decedent fetus. Just one category under the wrongful death statute that allows recovery for the pain and suffering while conscious undergone by the decedent. We are not arguing that there cannot be a claim for the loss of consortium for the decedent fetus, the loss of companionship society that the family would be entitled to claim and ask for. Whether an unborn fetus was able to consciously comprehend pain and suffering would be a question for a medical expert. And there is no expert testimony here to support that this decedent fetus here suffered any pain and suffering consciously upon birth. All the experts who will testify at trial have been deposed, and none of them opined that the fetus, more likely than not, consciously had pain and suffering. Plaintiff relies heavily upon their pathology expert and these findings within the lung of the fetus, arguing that these findings, this inflation and changes is more likely than not either the baby had CPR or the baby took a breath. Dr. Wilson testifies that she was not provided the medical examiner record that states the attending physician performed CPR on the child upon birth. The overwhelming record evidence shows that the baby was stillborn, had no signs of life. Dr. Smolinski is the only expert, only physician who has said that to a reasonable degree of medical certainty that the baby did not show any signs of life. And even if we were to accept that the baby did take a breath upon delivery, there's no evidence or expert testimony that the baby was conscious or otherwise suffered pain or mental anguish at that time. There's no expert testimony in this case to suggest that the fetus had conscious pain and suffering while within the womb. That would be pure speculation at this point. And so this argument or suggestion that the baby took a breath is not relevant and therefore should be inadmissible at trial. And even if there's a nominal relevance to the baby's outcome, it has a risk of misleading the jury to make an emotional decision and to award damages that they shouldn't otherwise award. Thank you.
Thank you. All right, Mr. Kybren.
Thank you, Your Honor. A little surprised because the motion that they filed seemed to, they suggested that all damages, non-economic damages, should be excluded. In fact, in paragraph 20 of their motion, it said because the fetus did not survive, all non-economic damages under the wrongful death act should be excluded. And that was a misrepresentation of the law in this state. That's not what the wrongful death statute stands for. That's not what the O'Neill case stands for. Today, they're talking about conscious pain and suffering for the decedent. So let's talk and focus on that issue alone. Dr. Alicia Wilson, she's the head of pathology at University of Michigan in Washington County. She reviewed this matter at length. She took all the information that Dr. Bader Casson had, who unfortunately passed away, and was retained by our office as an expert, but he died in the midst of this lawsuit. That's why Dr. Wilson had to be substituted and brought into the case. Baby girl Obenauer's lungs were inflated on autopsy, and that's a very significant finding, and here's why. If it's a stillbirth where the baby dies in the womb because of maternal hemorrhage, lungs are normally collapsed. But in this case, the baby's lungs were inflated. That's in the autopsy finding of Dr. Bader Casson. That's in the testimony of Dr. Alicia Wilson and their own expert, Rebecca, I'm going to butcher the last name, I apologize, is Dr. Barnian. Also, Bergen, thank you, Counsel. And Dr. Bergen. And everyone agrees there's only two ways that the lungs are going to be inflated. First way is either the baby took a breath or two. That would be reason number one, or the baby received CPR. And that's the second possibility. There's nothing in the medical records that suggests, and their own pathology expert concedes, I did not see any evidence of any resuscitative efforts. Now they mentioned Dr. Smolinski. Dr. Smolinski is Dr. Sherfran's partner at his clinic. He was deposed after much objection in this case. He did an emergency C-section at the hospital. He did not care for the baby. His testimony was, I did the C-section, I handed the baby off to the nurse, I went back and tried to resuscitate Nicole. He did not witness what resuscitative efforts took place. So he can't come in and say one way or another whether the baby took a breath, whether there was CPR. But what we do know from the actual medical evidence is that the baby's lungs were inflated when they should not have been if it was a stillbirth, which means the baby, more likely than not, took a breath. And our pathologist, Dr. Alicia Wilson, testified about that. And their own expert concedes to it and described the manner of death. So this is really a question of fact. And Judge, since they're trying to exclude non-economic damages, which is what their motion is titled, this is an MSD, not a motion of limit. That deadline has passed. They should have brought this motion early on when we've been done with the expert discovery for months. They never brought this motion. So for now, now for them to come forward and say, well, we can't present evidence of conscious pain and suffering, and we should not be allowed to claim damages. Well, there's no proof. They have not presented this court with any proof, any sworn testimony from any of the retained expert, and they have many, that it was because of the CPR that the baby's lungs are inflated, not because of the baby not taking a breath. They have not given any of that information to this court. In fact, both Wilson, Dr. Wilson and Dr. Burgeon, forgive me for mispronouncing her name, testified, we did not see any evidence of resuscitation in the records. And so it's possible that the baby took a breath before the baby died. So for those reasons, I think this motion should be denied. If we cannot sustain our burden at the time of trial, they can move for DV on this issue. But for them to preclude us from being able to talk about evidence now, which all the experts have talked about, I think it would be inherently unfair to the plaintiff and prejudicial. So I think for those reasons, this court should deny the motion. Thank you, Judge.
Okay. And Ms. Henderson.
Just briefly, Your Honor, the defendants did not object to Dr. Smolinski's deposition, but he did chart in the record that when the infant was delivered, and this is defendant's exhibit E to the motion, there was no pulse, no respiratory effort, no cry, no color, ABGARs of 0, 0. So the fact that there are no records to suggest the breath occurring or not occurring, the baby's status is documented within the records, and the experts stating that they did not see any records of CPR being administered is because they were not provided the medical examiner's record, which is exhibit F. They were provided autopsy reports and photos, but not the narrative that says Dr. Brock attempted CPR without success and pronounced baby opener at 412, and that's page 3 of 7 on exhibit F. And Dr. Brock also stated in his interview with the medical examiner within an hour of the pronouncement that Dr. Brock stated baby open hour never took a breath. So regardless of Dr. Smolinski's personal observations, the record is clear that this is not an issue that has any relevance to the claims that will be presented at trial. The defendants do not need to disprove what plaintiff must prove with respect to the baby's consciousness and ability to recover for conscious pain and suffering. This is not necessarily a question of credibility. There is no relevance to this line of evidence or argument because the plaintiff cannot make that claim. So we appreciate that the motion perhaps was not articulately titled to suggest the narrow scope of it, but we did want to clarify that it's just the one subset of conscious pain and suffering on behalf of the decedent fetus's estate is what we're seeking to exclude evidence of. So thank you, Judge.
So I'm going to deny the motion. In this case, damages and for the reasons in the plaintiff's response, but damages for conscious pain and suffering are available under the law and generally are a matter to be determined by the jury. Any evidence or arguments relating to the baby girl open hours conscious pain and suffering are admissible. Such evidence is relevant to the question of damages pursuant to MRE 401 and therefore admissible under MRE 402. To the extent that evidence at trial supports plaintiff's argument, the jury would be permitted to return a verdict in plaintiff's favor, but obviously that is a question for the jury. So I am going to deny the motion in limine on this one. Okay.
Thank you.
So I think that leaves us with defendant's motion to compel Sailor's accounting and tax specialist to comply with subpoena and for sanctions against Sailor's Accounting and Tax Specialist Inc. for failure to comply with subpoena for records.
That motion is moved. It's my understanding that we've withdrawn that.
Oh, excellent. Are there any other motions?
I think that's it.
Okay, so I'm on file 6. So I don't even have a scheduling order. Do we already do the settlement conference or is it coming up?
It's today, Judge.
It is today. Okay, so we have a couple options. I have a family law matter I have to deal with. So I can have you guys go have a seat in back and talk. And maybe have a game plan where we can set a trial. Obviously, I'm going to be out of the country for a little bit, but a trial wouldn't be till fall anyway. But so my bailiff will let you take all your stuff and go back when you're ready, and we can make some coffee for you if you want that. And I'm going to go back and talk to the civil inspector. And are there orders in these or?
There were orders for granting, but we can prepare a
Thank you.
Alrighty, friends. Let's stay in Michigan. Go to Judge Elmore.
Now for the 28th Circuit Court here in Wexford County. And we don't have a very busy day this morning, but we're going to begin by taking up the case of people in the state of Michigan versus Gregory Ray Miller Jr. The file number here is 26-14243FH. Appearances from counsel.
Good morning, Robert Champion, appearing on behalf of Mr. Miller, who is seated to my left.
All right, thank you. We're here today for an initial pre-trial conference. Counsel had informed me in chambers that there would be a resolution today with a plea of no contest. And I have received a written copy, a copy of the written pre-trial agreement. As I understand it, the defendant, who is currently charged with domestic violence third as a fourth habitual felony offender, will be pleading no contest to the domestic violence in exchange for the dismissal of the habitual offender. I said habitual offender third, I meant fourth. It's a habitual offender fourth. That portion will be dismissed. Is that a correct statement, Ms. Lawrence?
Yes, Your Honor.
Are there any other terms to the agreement that you are aware of?
No, Your Honor.
Mr. Champion, do you agree?
I do, Your Honor.
Thank you. All right, Mr. Miller, is that how you wish to resolve today's case, sir?
Yes, Your Honor.
To the best that you can, please raise your right hand for me. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, Mr. Miller. You may lower your hand. Mr. Miller, back on April 4th, which is only about a month ago, were you on probation, parole? No. All right. And were you on bond pending any felony charges anywhere at that time?
No.
Now, as I mentioned a moment ago, there is a felony information, which is just a charging document, a couple pieces of paper here in the file. And it charges you with a single count and a sentencing enhancement. Let me explain that all to you. Count one is a charge of domestic violence as a third or subsequent offender. So typically, domestic violence is a misdemeanor punishable by up to 93 days and or up to $500. However, if this is a third, based upon what it looks like, you haven't been convicted previously of 2 domestic violence convictions in Osceola County, one on October 4th of 2012 and a second on July 3rd, 2013. That makes it now a felony punishable by up to 5 years and or up to $5,000 in fines plus costs. Now, there is this thing that I called earlier a fourth habitual felony offender enhancement. That means that with that enhancement at the time of sentencing, within the discretion of the court, that maximum punishment could be increased from up to 5 years to up to life. And that would also impact the sentencing guideline recommendations. However, I'm told today that you're going to enter a plea of no contest to that count one. And if I accept that plea, the prosecutor agrees to dismiss the fourth habitual felony offender, which brings that maximum punishment back down to up to 5 years and or up to $5,000. So far, is that what you understood you were doing?
Yes, Your Honor.
Okay. Now, I talked about you entered a no contest plea. No contest plea is a lot like a guilty plea. It still has the same impacts. The difference is instead of requiring you to recite a factual basis, I'm going to look at something else, such as a police report. I can take a no contest plea in a couple instances. One, based upon what they call the interest of justice, which really just means, judge, you got some discretion. The other is if you had a potential civil liability, you could be sued for any injury that you caused. And the third could be because of lack of memory. That memory may be because it's so long ago, or it could be because of intoxication, which is what I understand is the situation here. Do you understand?
Yes, sir.
Do you have any questions about what a no contest plea is?
No.
Now, I have in front of me, as I mentioned, this pre-trial agreement, and I'm going to hold it up. It's pretty simple, but it looks like it has your signature there on page 2. Is that your signature? Now, before you place your signature on here, did you talk to Mr. Champion about the charges, the evidence against you, your options, and the offer?
Yes.
And did he answer all your questions for you?
Yes, sir.
And was he responsive in answering those questions? In other words, he wasn't hiding the ball or whatever?
No. Yes, sir. He was
good. And are you satisfied with his representation as of now?
Yes, sir.
All right, great. Thank you. Now, by entering a no contest plea, you're not going to have a trial, and I've already mentioned that. And the parties have given me this form at the top that says advice of rights, and I'm holding it up for you. And at the bottom, it looks like it has your signature. Is that your signature at the bottom?
Yes, that's my signature.
Did you read? By the way, that's worse than even my signature. It's all right. Now, sir, did you read through all these rights before you signed it?
Yes.
All right. And did you understand all the words and rights that you read?
Yes, sir.
You understand even more importantly, if you enter a no contest plea, and I accept that plea, you will be forever waiving these rights on this document as it applies to this particular case. All right, thank you. Next, you also will be given up the right to claim that this plea was a result of any promise, threat, or inducement not told to me now on the record. So, other than the terms of the pretrial agreement that we've talked about, have there been any other promises, threats, or inducements to force or compel or encourage you to enter this plea?
No, Your
Are
Honor.
you therefore entering the plea of your own free choice, sir?
Yes, Your Honor.
Now, Mr. Champion has undoubtedly talked to you about potential sentencing and tried to give you an idea as to what he thinks the court may sentence you to. He's probably talked to you about the Michigan sentencing guidelines, which establish a minimum end of a sentence for a felony. And he's probably tried to talk to you a little bit about what Judge Elmore would do, because he's in front of me quite often. The key question I have for you is, has anyone promised you exactly what the sentence would be? Those sentencing guidelines, and I know were mentioned to you because we already talked about this document, the plea agreement, and at the bottom it even estimates the sentence guideline range from the Michigan guidelines at 0 to 17. Now, first of all, I want to highlight for you, it says the word, it's an estimated range, okay? Next, the Michigan sentencing guidelines are not mandatory. Now, the courts must consider them, but we need not follow them. There are certain rules that apply to it. I just want you to understand that that's an estimation, and I don't know what the sentence will be. You understand?
Yes, sure.
Because after a plea is taken and entered, there's something called a pre-sentence investigation report that will be prepared. And that tells me a lot of other information, such as how you've done on probation or bond in the past and so forth. So I don't know. I've met you before, maybe, and I'm not saying that negatively, right? It's a small town. It could even been out in town, but anyways, I don't know everything about you. Good. Do you have any questions now before I take this plea?
No.
I'm not telling you what you have to plead, but when I get to this next stage and I ask, how do you plead? Because people watch way too much TV and movies, they always say guilty, even though I know or expect it to be a no contest plea. So as to count one, how do you plead?
No contest.
All right, thank you. Ms. Lawrence, I have in front of me People's Exhibit number 1. Are you asking the court to entertain that for the plea?
Yes, Your Honor.
Mr. Champion, any objection?
No objection, Your Honor.
Thank you. People's Exhibit number 1 is hereby admitted. Now, before I talk about this, Mr. Miller, I want to make sure you understand something. I should have said this earlier. Anything that's in here, I get to consider for even sentencing purposes. I don't want to dissuade a person from ever coming up and making a fair, honest argument later on. But if you try to later come back and say, well, that's not really what happened, I can't take, you're stuck with what's in here, okay? Because first of all, I'm being told that this is being accepted because of intoxication. Is that what you understand as well, sir?
Yes, sir.
All right. I just want to make sure you understand that when I take a look at this exhibit, all the information is, I'm not stipulated as like a fact, but I get to use it. Everything we talk about is going to be based upon it. All right, thank you. So again, People's Exhibit number 1 is hereby admitted. The court takes particular notice that in comparison with it and the felony information, the date of on or about April 4th of 2026, and then the jurisdiction of the city of Cadillac in Westford County here in Michigan are well detailed on the front page. And also that Mr. Miller's name is referenced in here, more particularly beginning on I'm sorry, and by the way, this report is 8 pages long. Beginning on page 3, that's when there is some evidence talking about what happened between the defendant and a significant other named Wendy Reynolds. In fact, there's even further information specifically provided by Miss Reynolds that begins on page 4 and continues on to page 8. Miss Lawrence, do you believe that the interest of justice do not require the defendant to recite a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe this report provides sufficient facts to establish the elements of the offense?
Yes, Your Honor.
And the report's compliance with Rule 6.302?
Yes, Your Honor.
Except I have to ask him about the prior convictions in just a moment. Other than those, Mr. Champion, do you agree with all of that?
I do, Your Honor.
Thank you. Mr. Miller, I will have to ask you one question, actually 2, but they're based on the same purpose. Is it true that back on October 4th of 2012, down in the 77th District Court in Osceola County, which of course is in Reed City, you were convicted of a prior offense of domestic violence?
Yes.
Is it also true that on or about July 3rd of 2013, in that same court, in that same county, you were again convicted of another charge of domestic violence?
Yes.
All right, the court first finds that the interests of justice do not require the defendant to recite a factual basis based upon the level of intoxication, which is reported in People's Exhibit number 1. The court also finds that Exhibit number 1 has sufficient evidence to satisfy the elements for count 1, in addition to the statements made by or admissions made by the defendant as to his prior convictions of domestic violence, which makes this a third or subsequent offense. The court also finds the defendant's plea today has been made freely, knowingly, and voluntarily. Therefore, the court finds the defendant guilty of count 1. The habitual offender enhancement will be dismissed at the time of sentencing. Mr. Miller, we do sentencings in this court generally on Monday mornings. And I can predict that yours will be set in about 4 weeks from this coming Monday. Between now and then, an agent from the Michigan Department of Corrections, which is also known as the Probation and Parole Office, will prepare a pre-sentence investigation report. One of these reports is required anytime someone is convicted of a felony in a state court here in Michigan. That report will include a description of the offense, description of the pretrial agreement, statements that you make or provide while it's being prepared, and we'll talk about that in a second. Maybe statements from the victim, Ms. Reynolds in this case. It will also include a description again of the offense, but also a description of any prior criminal history you have and information about your performances on bond, probation, or parole in the past if those are relevant. It will also include a scoring of the guidelines, which once again, I remind you are not mandatory. It will also include a recommendation as to the sentence. Please keep in mind it is merely a recommendation, as it is the court alone that will determine the sentence. Now, between now and then, there are 3 steps that involve you for the preparation of this report. Number 1, when you leave here, and Samantha's getting ready to give a packet to the corrections officer. They're gonna give you a packet. You're gonna open it up, fill out all the information, turn it back in. Because you entered a no contest plea, there's a section in there where it asks you describe what happened. Clearly, because you had told me about it, there was a no contest plea and therefore had lack of memory due to intoxication. It's okay if you don't answer that, because I don't expect you to know what to put in there. You should don't remember it. Hopefully that makes sense. You also will be subject to an interview with an agent from that office. You have the right to have Mr. Champion present during that interview. And third, once this report is prepared and provided to the court and the parties, which is generally about 10 days to 2 weeks before we come back, Mr. Champion will have to meet with you and go over it. Each side has the right to come back to this court and request corrections or objections to content or scoring. Now, because I see that you had a fourth habitual felony offender, often the Department of Corrections will use old versions of pre-sentence investigation reports as a basis. In my experience, not every court nitpicks those reports like we do, or I do. If you see something that's an error, by God, let me know, and let Mr. Champion know. He'll let me know. And we need to get that corrected. For instance, there's often errors about birth dates, names, family members, if you had any rehab, where you went. And sometimes, although it's extremely rare, there'll be information in there about somebody else. It's not you. And in the military, we call it passing our trash. I don't like to pass trash, so I want to make sure it's correct when it leaves this courtroom. All right, thank you. Do you have any questions about what we have done today?
No, Your Honor.
All right, great, thank you. Miss Lawrence, anything further on behalf of the people?
No, Your Honor, thank you.
Mr. Champion, same question?
Nothing further, Your Honor.
All right, thank you very much. The court revokes bond, remains in immediate custody based upon the entrance and finding of the conviction. Thank you. We should see you all in about 4 weeks. We are adjourned.
All righty, friends. TCF Live. About 40 more minutes or so to go today. We will go to Dungeon Court to end our day, but before we do, let's go to Lake County, Ohio. Judge Collata just took the bench. Let's see what's going on there.
Case number 25 CR 1679. The defendant is present in the courtroom with his attorney, Mr. Walt Edwards. We're before the court for purposes of sentencing, the defendant having pleaded guilty and been found guilty of count 2. It's a felony of the second-degree robbery with a 1-year firearm specification. Also count 6, felony of the third degree, having weapons while under a disability. Parties are ready to go forward, Your Honor.
Thank you. All right, Mr. Edwards, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Briefly, Judge, I have been in receipt of the pre-sentence report. I believe it to be fair, accurate, and complete. No additions, deletions, or corrections. I've also received the psychological evaluation by Lisa Friend, and I would stipulate to the findings contained therein. Judge, I would thank the state of Ohio for negotiating in good faith towards what we believe is a fair and equitable resolution to this case. You know, this is an unfortunate event by someone who, you know, notwithstanding a conviction in Cuyahoga County from last year, did not have a significant history of violence. As a child, he had just a few juvenile adjudications, none of this sort. The prior conviction out of Cuyahoga County with his father, we discussed off the record the circumstances surrounding that, and it is, I would say, not a typical situation. Here, I would respectfully submit to the court as well that this is not a typical robbery. When you think of a robbery, you think of a sort of predacious motive or profit motive-driven act. This is something that evolved very quickly. As I understand it, my client had just gotten off at work at Condado. He had met up with 2 other individuals, one of whom made arrangements to meet with the victim to secure some marijuana. The victim then ended up entering the vehicle that all 3 were in. The victim had a gun, and there is some dispute as to, what happened between the victim having his gun and Mr. Gardner leaving with his gun. But what I would say is we've stipulated to a factual basis to say that there is a robbery. He forcefully took the gun away from the victim. I would ask that the court consider that, I'll call it a sort of labored acceptance of responsibility. He didn't immediately acknowledge what he did here, but he did ultimately acknowledge to the police what he did, which fits the statutory definition of robbery. But I don't think when he woke up that morning, certainly when he got in that car, he never intended to steal anything from someone by way of force. That said, he's been a pleasure to represent. We have never had a bad moment. He is very polite, very respectful. The only thing I would say, and I know I stipulated to the friend report, but he had an IEP in school. The reason why he was referred is because I believe, just in my encounters with him, that there are some cognition issues. I'm not suggesting that that is at all an excuse for what occurred here, but I would say, looking through a broader lens contextually, that I think he has some cognitive issues. And how does that impact him? Well, it impacts his ability to navigate through stressful situations in a rational way that most people would.
Maybe marijuana attributes to that as well.
I don't disagree with you, Judge. I think, he has maybe these deficits, and then that is only compounded by the fact that he is further numbing his brain through the use of illicit substances. So the marijuana just makes it 10 times worse. But again, I would submit to the court that based on my interactions with him, he is someone worthy of the discretion of this court. He is only 19 years old. I would ask the court consider, sort of system of graduated sanctions, give him an opportunity to have a meaningful young adulthood instead of, a number at the higher end. I'm asking that the court consider a 3 or 4 year term. And here's another reason why that might be appropriate under the circumstances. He does not have, because of the structure of the plea and his prior conviction, an opportunity to petition the court for relief under the judicial release statute. He cannot earn good time. He cannot kite a social worker for transitional control. So whatever the court imposes is the term that he will do, notwithstanding, the potential for doing additional administrative.
Isn't that the way it's supposed to be?
I'm sorry.
Isn't that the way it should be or supposed to be?
Well, I don't know here.
I mean, I know.
Yeah.
Whatever. I understand. I understand what you're saying.
Yeah. The only thing, as an aside.
I mean, if that's the case, then I should keep taking into consideration when I sentence somebody that can get this breaks, to give them more time so they do the amount of time I really want them to do.
No, and I get it. I hear you. My biggest thing with all of that is like taking away good time from people, because it creates a disincentive to not engage in bad acts while you're there and engage actively in programming. So that said, again, I would thank the state of Ohio. I would thank the court for its patience, and I would respectfully submit that a sentence near and around the bottom of the range is sufficient to protect the public and punish the offender, and consistent with the purposes and principles of felony sentencing. Thank you, Judge.
Thank you. Mr. Gardner, you have the right to address this court before you're sentenced. You can say anything you want. Is there anything you'd like to say at this time?
Yes, sir.
Go ahead.
I highly regret what I did. I don't really think the act that I did was fair or right to do. In my eyes, I thought I was defending myself, but I didn't think of the eyes of the law. So I deeply regret doing what I did to my victim. I'm sorry to my victim. I hope our victim knows that I didn't mean to do it. It was just the attention and the ear that I felt, and I deeply apologize for that. I'm really not a person that goes looking for trouble. I really stay back to myself, work, and I got love for my nieces and nephews. I like to be around my little ones the most I can. So I just hope and pray that today you could like give me a reasonable time to do, so I don't have to spend a lot of time away from my family. I'm not saying this is a bad situation, because I could turn this situation to a good situation when I go down the road and make something out of my life and take programs, even if it's not for good days, it's still better my health. And I can just see that and mature up in life, come out as a responsible man and and fulfill the needs of my family when I come out. That's all I take out of this.
Thank you, Judge.
Thank you. Mr. Shapiro, on behalf of the state of Ohio.
Thank you, Your Honor. As Mr. Edwards stated, this is mandatory prison by operation on the underlying offense by operation of the defendant's prior F2 conviction. I was just thinking about what the defendant said, Mr. Edwards, and I was just looking at the pre-sentence report. It shows that through the juvenile division of this court in September of 2023, the defendant was ordered to complete the court's intensive community rehabilitation program. I don't know what that is, what kind of treatment programming that entails, but it looks like there was some sort of a program here that was offered to the defendant in the relatively recent past. It was a couple of years ago. He was before Judge Shaughnessy downtown in September of 2025, September 29th actually, which is about 2 months prior to the defendant committing this offense. And in as much as the defendant was employed at that time, he was working at Condado Taco in Menor, he also was getting off work and smoking marijuana, which was a violation of his probation at the time. And that was right after he was in a courtroom with the judge telling him not to do that. We also have, Your Honor, detailed in the pre-sentence report a number of sanctions and behaviors of the defendant breaking the rules within the jail, which is the most structured environment we have in our society, where as much control as we can exert on someone to follow the rules is in a jail. And within those parameters, the defendant cannot conduct himself within the rules before him. And some of those were even violent encounters in the jail. And maybe that trouble came to him, like he's saying, and he had to deal with it. But there's a lot of inmates over a lot of years that the trouble doesn't come to them. So I don't know if it's a coincidence, Judge, and certainly not a coincidence the defendant took this gun and disseminated it on the street. Now, that's what he told the detectives, and it makes sense because the gun was never recovered anywhere at all, let alone right next to the car. The defendant says in his pre-sentence report, what I actually did is I got out of the car and I placed it on the ground and ran away. It defies common sense. It's not consistent with his thinking that this victim was going to use that gun against him. So I'm not sure what to think at this point in terms of what happened from his perspective. I can tell you what the victim told me, and what the victim told the police was that that was not the case. Now, the victim does say that he did have that gun out in the back seat, and that the defendant did tell him, hey, put that away. I'm not saying that's not true. The victim acknowledges like that. Mr. Edwards said there were a good number of consistencies here, and that's true, up until we get to the point where there's aspiratation of the gun. Then there's differences. Either way, Judge, we have a gun with a 50-round mag, drum mag, that was disseminated on the street for no good reason because of what the defendant did. So this is not, from the state's perspective, a situation where the minimum would satisfy the purposes and principles of sentencing. Based on the defendant's conduct, the fact that there was injury here as well, and I mean we have a short history, but it's chock full of violations in a short period of time. I would ask the court to consider that and fashion a prison sentence that's commensurate with all of that. The state believes it's more of a mid-range situation. The defendant does have credit for 150, that's 150 days. I have no requests or figures about restitution to present to the court.
Thank you. Court reviewed the pre-sentence report and investigation, psychological evaluation. I've considered the facts and circumstances of the offenses involved here, the nature of these offenses. I've considered what's been said here today by the defendant, his counsel, the prosecutor, the recommendations from everybody. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. So the factors in 2912, court finds the victim here suffered serious physical harm as a result of the conduct involved. As for the recidivism factors, the court finds many of these are present. Defendant was on probation or community control sanctions to Cuyahoga County at the time he committed this offense, and the offense that he was put on community control sanctions was for an offense of violence involving a firearm. He was put on community control on September 29th of 2025, and then 2 months later he committed this offense. He has a history of juvenile delinquency adjudications and criminal convictions as an adult. He was only 19, but he's got the prior, as I mentioned, felonious assault with a gun. He's not complied with previously imposed sanctions ordered by a court. You're on probation and you're smoking weed, you're possessing firearms 2 months after being put on probation. Doesn't sound like somebody that wants to do what you just said you wanted to do. While in our jail, you consistently have been getting in trouble. And a lot of that trouble involves violence, fighting. And I find it hard to believe that you're always the victim in all of these. Always in the position defending yourself. You don't have this many incidents incidents involving violence when that person is always the victim, is never the one instigating anything. In regards to the seriousness factors, I'm also going to note that you put a firearm with a 50-round drum into the community. Your statement that you left it on the sidewalk doesn't make sense, and you've changed that story. It's not what you said initially to the police. You told them you got rid of it, you sold it. Now you say you left it there, which is completely inconsistent with your version of what happened. You wouldn't take it because you felt your life threatened and then just leave it there and walk away when the victim can just go get it and shoot it if that's what you were really worried about. You put a gun with a 50 drum, again, magazine into the community. I don't know if drug abuse problem related to the offense, but there's certainly a drug abuse problem here. You for the last 2.5 years, smoke an ounce of weed a day. 25 blunts a day. There's only 24 hours in a day. Assume you sleep a few hours. So you're just high all day long. 25 blunts a day. So you're smoking like a couple blunts every hour? How much is an ounce of marijuana?
Like 28 grams.
Yeah, 20 grams. Couple $100?
90.
Your work history shows that you worked for 1 month. So where'd you get the money to buy $90? And I think that's low, quite frankly, but I'll go with your figure. $90 a day. So you're spending $630 a week. What's that? $2,500 a month you're spending. $30,000 a year. Smoke marijuana every day. Where'd you get that money?
I helped my friend, dad, paint houses.
You didn't tell probation about that when they asked you about your employment history.
Because I wasn't employed.
Huh?
I wasn't employed. I was under the, like, I was never hired. It was just
You were
like-
working and getting paid, you're claiming. That's being employed. If you really did that. So you had $30,000 just to throw away every year on marijuana?
No, sometimes I got it for free.
There's no factors indicating recidivism is less likely. Under 2913B, well, that's irrelevant here. There's a mandatory prison term. The court finds there's a mandatory prison term. Prison is consistent with the purposes and principles of sentencing. And the defendant is not amenable to available community control sanctions. Therefore, it'll be the sentence of this court on count 2. Defendants serve a mandatory indefinite prison term of a minimum of 4 years, maximum of 6 years. Count 6, he serve a prison term of 18 months. That'll run concurrent to count 2. Both of those terms, however, shall be preceded by a 1-year mandatory prison term for the firearm specification, which again shall be served prior to and consecutive to the prison terms imposed in counts 2 and 6 for an overall mandatory prison term of a minimum of 5 years, maximum of 7 years. There's 150 days of credit which the defendant will be granted. Need to advise you upon your release from prison, you will be placed on post-release control for at least 18 months, up to possibly 3 years. If you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Defendants award the penal cost incurred in this action. The balance of the indictment will be dismissed as agreed to, as well as any other specifications. Court further hereby advises you that there is a rebuttable presumption that you will be released after you've served the minimum sentence, which is 5 years. Now, that's not guaranteed, but there is a presumption that that will happen. However, that presumption could be rebutted, means overcome by the prison officials if it's found during a hearing that you'd be entitled to have if they don't want to let you out after the minimum. That while you were in prison, you violated the institution rules. You committed infractions of the rules, you misbehaved, you were not sufficiently rehabilitated, you are a threat to the community or society. If that's determined to be the case at a hearing, then the prison officials don't have to release you at the minimum. They can keep you in longer. They would then pick a new date for you to be released, and there'd be a presumption that you'd be released on that new date, unless, again, they determine at a hearing that you continue to commit rule violations, you're a threat, you're not rehabilitated. Under no circumstances, however, can you be kept in beyond the maximum sentence. So even if you misbehaved the whole time you were there, you still have to be released after you've served the maximum sentence, which in this case would be 7 years. I think that covers everything. Mr. DePiero, is there anything else we need to address or that I've omitted?
No, Your Honor.
Mr. Edwards?
We would thank the court.
All right, thank you.
Alrighty, friends, it's that time. That time when we experience Appalachian justice, which of course is best held in a cold, dank basement with blood-red carpet, the screams of the dead heard in the background, lighting from the Soviet Cold War era, the printer that never stops running, a judge who famously once had dinner with Methuselah himself, he's so damn old. It's a scary, scary, scary place. And by the way, for those of you who aren't aware, back in the day, we actually created a brochure for this place, and I just dropped a link for it in the chat so you can grab a virtual copy of it for yourself, so do check that out. Ladies and gentlemen, our Friday Guilty Pleasure, I give you Dungeon Court.
Went through a divorce and then a bankruptcy, and I'm getting back on my feet.
Okay, but you have no income coming in right now?
No. Just a little odd jobs here and there, but
I'll appoint Mr. Stratton to represent you. We'll get him in the courtroom. We'll have to fill out a financial affidavit swearing to Mr. Stratton. This is Harold Irwin. It's a first-degree misdemeanor driving under suspension.
Oh, okay.
He's entered a not guilty plea. What I propose would be go out maybe a month or so to give a chance to try to clear things up. Let me see if I can see what the DMV is saying the problem is. Well, there's an administrative license suspension from Chillicothe Municipal Court that runs through January of 2027. And well, there's a prior out-of-state suspension, but it's been released, so that looks like the problem. Chillicothe Municipal Court.
Run through, you say January of 27?
Yes.
Okay.
Mr. Irwin can sign a $1,000 OR bond, and he will need to go to jail to get fingerprint. So, what's your schedule in June?
I have a few dates unavailable. The 8th, 22nd, and 29th are not good.
Let's do the 5th, June 5th.
All right, Your Honor.
June 5th, 10 o'clock, not good to see you.
All right, thank you, Your Honor.
You're welcome.
Stable High versus Austin Compton, case number PRD 26594.
This is also driving under suspension, and you're Austin Blake Compton?
Yes.
Mr. Compton, the state's alleging that on April 13th of this year at 9:37 p.m. in South Point, that you were driving a vehicle while you were under suspension. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand this charge?
Yes.
Do you understand your rights?
Yes.
How do you plead?
Not guilty.
Do you wish to have a court-appointed lawyer?
I don't know if I need one. I wasn't suspended, I didn't think, but apparently from my last court date that I had, I didn't show up, and they gave me a bench warrant. I had no clue that that was an automatic suspension of your license, so I guess.
Is that in Kentucky?
Yeah, that was in Kentucky, and I ended up paying the warrant for that, so I thought it was squared away at that point, but it wasn't, and yeah.
Well, I can give you some time to try to get it straightened out.
I was actually lucky enough, it was gonna be a week later that I was unsuspended. I got a copy of my new license here.
Okay.
It was May 31st, or May 31st, or April.
It was issued yesterday?
Yeah.
Okay, let's show that to Mr. Hill and see if he's satisfied. It's not driving under suspension, looks like you got it.
Well,
the license issued yesterday.
Sorry to cut you off there. The reason that I actually had no clue that it was suspended too is the license on the back there. It'll show that I had 1016 Racing Avenue on there. My new address is 1120 James Court in Ashland, Kentucky, and that's the only reason that I was actually behind the wheel. I wouldn't have risked it. I got a son, and I wouldn't have risked jail time.
Okay, so this looks like a temporary license until they send him the new one.
Correct.
It's satisfactory with us.
All right, we'll dismiss it, sir. You're free to go.
Thank you, sir. You guys have a good day.
Too.
State of Ohio versus Jared Pratt, case number TRD 26611.
Answer, you're Jared Scott Pratt.
Yes, sir.
Same thing. Got a
Yes, sir.
Extraordinary suspension here. States alleging April 15, 2026 at 5:53 PM, Chesapeake. You were driving with a suspended license. That's a first degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. You understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead?
However, he just pled, I'd like to talk to you about it as well.
You got some proof that you're reinstated?
Yes, sir, and I
Show it
got,
to this guy over here, that's the prosecutor.
and he also said I need to show you my copy of my license.
Okay, show it to, they file the charges, I don't do anything to file charges.
Yes, sir.
The printout,
And I got it squared away and active the very next morning.
And Your Honor, this is a letter from the Lawrence County Department of Job and Family Services saying that his license was successfully reinstated on April 16th.
yeah, that's what I've got a DMV printout and file saying the same thing, I don't know why you got, well, that was the day after, okay. So you satisfied?
Yes, Your Honor.
We'll dismiss it, you free to go.
Thank you so much.
You're welcome.
State of Ohio versus Kimberly Spangler, case number CR 26224.
All right, Ms. Spangler, it's alleged that Rome Township on March 31st of this year, you purposely tried to deprive Sean Patrick of property without his consent. That's a first degree misdemeanor theft offense, maximum penalty is 6 months in jail, $1,000 fine. You understand the charge?
Yes,
You understand your rights?
yes.
How do you plead?
Not guilty.
Okay. You want a lawyer appointed to represent you?
Yes.
Do you have a job?
No, I get.
You're in treatment, right?
Yep.
Okay. I'll appoint Mr. Morford to represent you. He's sitting right behind you. Entering a not guilty plea. I've got a report from, so, vote. Okay, so it looks like you've got things going in the right direction now. We just started with that, is that right?
Yeah.
So she can sign a signature bond of $1,000. You don't get her to the jail, she's supposed to be fingerprinted.
Yeah, I can take her down.
Okay. Supposed to require you fingerprinted at the sheriff's office. Yeah, that hasn't happened yet, I don't think. I'm thinking, since she's in treatment, just for more people don't need to come back until June. Are you okay with that? Okay, so let's set it for June 5th. For a pretrial at 10 o'clock.
State of Ohio versus Anthony Gianmarco, case number CRB 24724.
That's when you come back, give me a call. Thank you, Honor.
You're up. Okay, you're Anthony Gianmarco.
Yes, Your Honor.
You were supposed to be here on the 20th.
Monday.
I guess.
Yes, Your Honor. My ride didn't show. I'm terribly sorry.
Okay.
Your Honor, if I may, this is the one that you had me check on, said y'all know one day of community service. He did come in yesterday and do that day of community service.
Okay. You're finished then. Your case is
Okay.
completed.
All right, thank you, Captain.
You're welcome.
State of Ohio versus Brandon Helton, case number CRD 2318, CRD 213585, A and B.
Mr. Morford, I'm going to send you and Mr. Heel, hopefully this works, send you a transcript of a telephone call I got since I've been on the bench from a Shane Johnson, who's the representative at Hickory Recovery in Cambridge on that Bradley Williams that we have set for pretrial today. She says they're waiting on a pink slip from the jail, and I think they'll transport him. But I'll send it, and I'll send you the contact if you want to call her back. So I'm going to be, obviously I can't call her back right now, I'm going to be tied up for a while. Okay, Brandon Helton. This was set a week ago for review, and so as you weren't here then?
Yes, sir. I was in the process of moving. I just started a new job last week, so I had a lot going on. I normally set a reminder on my phone, but I guess I didn't do it for this one.
Okay, you have done some community service since your last hearing.
Yes,
So
and then I paid $30 today as well.
Okay, I see that. Tomorrow you get 2 days credit.
I'll work tomorrow.
Okay, next hearing is going to be
Could I do the 1st or 12th? 'Cause
June
I'm off.
1st.
June 1st. Thank you.
June 1st, 9 o'clock will be your next hearing.
Thank you.
You're welcome. Cancel the room.
State of Ohio recalls Nicholas Hughes, case number TRC 26521 A and B, TRC 252457 A and C.
Okay. You're positive for alcohol, and I saw you work around alcohol or something?
Yes, some of the solvents we use at work do.
Are you buying that?
Yeah, we actually send his labs off, yes.
Okay. All right. Let's get some of your other stuff done. You got a lot of community service still out.
Yes, I've been, yes, sir.
I'll set your next hearings. So Mondays or Fridays, what you prefer?
Mondays.
June the 8th.
Yeah.
June 8th will be your next hearing at 9 o'clock.
Okay. Thanks. Thank you, sir.
You're welcome.
State of Ohio versus on a recall of Veronica Howard, case number TRD 2375, CRB 21.
So on review, Ms. Howard is here now. She wasn't here earlier when called.
I apologize.
Do you have a payment on your funds?
I can put 20 on it before I leave today.
Community service, you still have community service. Tomorrow, you can get 2 days credit. I'm showing you to have 5 days left.
Yeah. 5 days? Is that what you said? Okay.
If you don't think that's right, you need to meet with Mr. Major.
Do you need this right here? My paper?
Your Honor, she is turning in some more community service.
Okay,
It will be accepted.
all right. I'll set your next hearing for June 1st. 9 o'clock is your next review.
State of Ohio recalls Norman Branch.
All right, Norman Branch is set for review hearing today. It was called earlier, wasn't here. You haven't done much on your case. You got community service and fines to pay. Do you have a payment on your fine today?
No, I start the court on next Friday. Overnight stay, whatever those 4 days.
3-day school?
Yeah.
Dip school?
On May 7th.
Okay. Yeah, that's gotta be done too. I'll set your next hearing for June 1st.
Okay.
9 o'clock.
What's my total? Not my total, but outside.
$710 and 5 days of community service plus the dip school.
So the dip school is separate from the $710?
Yes, sir. Yeah.
All right.
Driving under the influence is expensive.
I see.
Plus your insurance rates are gonna go sky high.
I see.
Probably cost you $5,000.
Yeah.
Get an Uber, they're cheap, or don't drink. Okay, June 1st is your next hearing.
Alrighty, friends, that will do it for today. I hope you all had fun this week. I did. Saw a lot of good court, had a couple of good sessions of sidebar, made some new friends, did some Dr. Seuss. It was a good week. So, in theory, we will be back on Monday. And I say in theory because most likely we will be. However, there's a possibility that we will not. Oh my, Lindsay, $50 super chat. Lindsay, thank you so much. I appreciate that more than you know. Thank you. Seriously. Wow. You guys are the best. Thank you. As I said earlier in the show, this is a very difficult time to be on YouTube because YouTube is messing with all of us, large or small, and it really comes down to community support for us to survive. So that means a lot. All the support that you guys give me. Lindsay, obviously, with the 50, but even just those of you who are here being active in the chat, you know, liking our videos, these are all very important things. So thank you. Anyways, I was going to say in theory we'll be back here on Monday. Most likely we will be. However, Mrs. TCF is on call for jury duty on Monday, and we'll call after 5 o'clock today to see if she needs to show up. So if you don't find us here on Monday, she had to show up. So we will see how that goes. But hopefully we'll see you Monday. If not, we'll see you Tuesday. But 9 a.m. Eastern, 6 a.m. Pacific, we will post videos throughout the weekend. So check back on the channel and enjoy those. But everybody have a great weekend. Take care. God bless.